Thank you so much for taking the time out of your busy days to come here today and I think have what are going to be some really rich and important conversations. As a way of introduction, my name is Ashley Williams. I am the chair of NYU's Native American Law Students Association, NYU's NALSA. Just for a bit of background on NYU NALSA, we were recently revived last year after about a decade or so of dormancy, and we are incredibly committed to remaining an organized student group on campus and continuing to elevate the voices of Indigenous students and people interested in those issues. We're excited to be having our first symposium as NALSA in partnership with a bunch of amazing organizations who helped plan and supported this event. We've entitled the symposium Law on Our Own Terms. And the goal of today is to engage with important Indigenous legal issues, specifically centering the perspectives of Indigenous leaders and scholars. Now, as we thought about, what would we want to hear as students? What would we want to talk about? We heard a lot about what's happening in federal Indian law, rightfully so. It's a rapidly changing environment. But what we really wanted to do was center Indigenous communities, Indigenous leaders, Indigenous voices, and that's what we're going to be doing today. So we have a full day of exciting events. We're going to start with our keynote conversation with Marguerite Smith. We'll transition to a panel on tribal jurisprudence, and then a panel on missing and murdered Indigenous women and girls, Two-Spirit people, and then we'll wrap with a conversation from the Lenape Center. So we have a full day. Folks are going in and out throughout the day and feel comfortable doing that yourselves. You probably saw the restroom just straight out the doors on the right, and there's drinks outside as well that will be there throughout the day. So welcome, thank you for coming, and we'll get started. All right. For today's keynote conversation, we have Marguerite Smith. Thank you so much for your time, Marguerite. Marguerite Smith is a citizen of Shinnecock Indian Nation and resides on her home reservation on eastern Long Island, New York. Ms. Smith is an attorney admitted to the bar in New York State. She's also an arbitrator, mediator, educator, and consultant in dispute resolution with special interests in human resources and Native American, multicultural, environmental, and social justice issues. We're also excited to have Marguerite with us today. She's going to be honored by the LACA organization, the alumni organization tomorrow, and I'm excited to see that as well. So we are in the midst of greatness, of course. So everyone, let's join in welcoming Marguerite. And how this is going to flow is I'm going to ask Marguerite some questions. Folks gave some input on thoughts questions they may have ahead of time. And then there will be time at the end of the conversation for you all to jump in. We do want this to be an engaged conversation throughout the day, so please feel comfortable in doing that. And so let's get started. Let's welcome Marguerite. I'm happy to have her. All right. So you're class of NYU Law 74, and you've been doing this work for a good amount of time. I didn't want to say, but that means you're incredibly experienced and you have a lot of insight to offer. But I'm curious, just taking us to the beginning, how did you get started in this work?
I was born. First of all, Tabani, Marguerite, he was supposed Natasuis, Natap Shinnecock, Natchapayawak Shinnecock, Natchashayawak Smith. I was born. I was born not on the Shinnecock Reservation because there's a hospital, and the hospital is not on the territory. But I was born. I was born into a family of activism. I was born into a family of dedication to preserving our lands, preserving our culture. When I finally took a look at your, I was invited, and I thank you for the honor of the invitation, but when I saw Law on Our Terms, I thought, well, that's exactly the story of my life. Because while Matt and Steve are excellent professors of federal Indian law, back then in the 1970s, the 1960s, we at Shinnecock were shaping law on our terms. We were not federally recognized. We had a territory. We were poor people on a territory that was acknowledged as an Indian territory. It was acknowledged by the state of New York. They had a little schoolhouse there. Actually, the schoolhouse closed 2 years before I would have entered school. My mother went to the school there. But we knew that we were, quote, Indians, specifically Shinnecocks, but we were a strange animal, I guess, in the work of federal Indian law at that time. Professors didn't know what to do with us. There was no Indian law program at NYU. There was no Indian law program most anywhere at that time. But so law on our terms for me means, what do you shape to preserve your internal cohesiveness, to preserve your culture, to protect your land, to protect it from internal forces that can pull us apart, and from external forces that are always trying to grab what we know Creator gave to us to take care of. So, how did I start? I mean, I grow up, my grandmother's going to court every day. My grandmother's a good woman. No legal training, certainly. No any kind of training. So, again, simply stated, I was born to this work. I have two younger sisters. One is a doctor out on the Hoopa Reservation in Northern California. My younger sister, who quit Dartmouth after about 3 weeks, is the cultural affairs director for my nation. So, again, I was born to a people who are strong and committed to preserving who they are and to evolving into being whoever we're supposed to be. And I do want to acknowledge Miss Ayana Cord, who is one of our young relatives. I'm hoping some of our other relatives will show up during the course of the afternoon. But some of us are born to this work.
Indeed. And so you spoke about what this work, what it means to do law on our own terms. But can you provide more context on the specific legal work you do today and how that's developed over your legal career?
Sure. Today, someone asked me recently if I was retired, and I said no, but I'm really tired. And that's the truth of the matter. But I'm actually not practicing for the nation at this point, but I am serving as a co-chair of our governance committee, which is to say we do a lot of work at looking at whether our governing documents fit what we're doing and what we need to be doing. I do a lot of work with, I'm on the steering committee of our Elders Council, where our current theme is aging in place, which seems to be a national movement. But we have our place. We don't want to go to nursing homes off territory. If we have to be in a facility off territory for a short or long period of time, we want culturally appropriate services. We want medicine that our people believe will heal them. So, and that tends to be transactional legal work. It's looking at contracts with the hospital, with the health departments, federal health department or state health department. It tends to be looking at documents and telling our own government, we call our elected government the Council of Trustees, we, and it's silly season, our election is next week, but we look at our documents and say, wait a minute, we decided to have a constitution just about 13, 14 years ago. We had not had a written constitution until then. We see what's going on in Israel right now, where apparently they do not have a constitution, but they have a dispute going on concerning the role of the judiciary. We haven't established a formal judiciary yet at Shinnecock. We have various kinds of often family-based dispute resolution services, and sometimes we'll come together in a circle, the elders convening with the particular disputants to attempt an understanding of the dispute, help them understand the dispute, and then come to grips with that. And Ayana's grandma was somebody who got me into that work years ago. She probably doesn't even know about it. Back in the 70s, Shinnecock was one of the two land-based in New York Indian tribes that were not, quote, known as treaty tribes, as federally recognized tribes. We were Algonquin people. I hope people happen to notice, I noticed a very strange thing this past Sunday. There were two articles of Native interest on the front page of the Sunday Times. One concerned a meeting with the state of New York and some Native leaders, both from downstate and upstate. One of their topics was the failure of the governor to sign a bill to protect burial grounds, unmarked burial sites. The other concerned the failure of the government to right the wrongs of 100 and more years ago against the Montaukets, who sat in the courtroom and were declared to be extinct. So another article was about the Yanomami people in Brazil, whose culture and lands are currently being they've long been under siege, but they're currently under siege by energy development companies. So that was, for me, quite a step to see the New York Times on Sundays got two pieces of Native interest. One used the word tribes. I think one of the headlines used the word tribes. The other said indigenous. Caught my eye, and I hope it caught others' eyes to say that the work of bringing the indigenous people out of the invisible into a state of inclusion, even if it's being at a table where you're adversaries, I think that's an important step that's happened. I did participate in about a 33-year period in the recognition efforts. I happened to come out of law school at a time of activism. Anybody remember Wounded Knee? Anybody remember any number? Well, we came out of, I guess, the war on poverty. You had the civil rights movement, and then the war on poverty brought many communities to thinking about how are they going to build their future. And that caused many of the East Coast peoples, the Algonquin people along the East Coast, began to think about how they were going to do this work. The courts began to entertain some of the cases, the main cases. The Oneida case, basically affirming that the 1790 Non-Intercourse Act did apply to the East. It wasn't just, this is a law, this is federal law that says you can't take the Indians' lands without approval of the Congress. Nobody thought that meant, not many people thought that meant us, our lands. And so we've been in, personally, my own career has been one of some disappointments, some steps in the starts and stops, do they say? Starts and setbacks, when you think you're on a track towards not only federal acknowledgement, in fact, primarily federal acknowledgement wasn't our thing. I signed a request to the department, to the Justice Department, to bring on a land claim in our behalf in the 70s. That got converted into a request to participate in a newly formed process called the federal acknowledgement process. And it was then, there's case law that's evolving as this goes along, and, over those 33 years. It finally, at one point said, well, you can't have a land claim until you've got the federal acknowledgement. So, of course, all these roadblocks are thrown up to prohibit the East Coast tribes from becoming federally acknowledged, so you didn't even have to, the courts didn't even have to deal with the land claims. So I've been deeply involved, was deeply involved in that from the beginning, with my own community and also through the Coalition of Eastern Native Americans with many tribes up and down the East Coast and into Michigan, the state of Michigan. What else have I done? I've done a lot of internal work. Before we use the term sovereignty at Shinnecock, we use the term self-governance. I remember being a little bit embarrassed when I first noticed as a young student our letterhead, which said we were the oldest self-governing tribe in the United States. Well, darn, go tell a Hopi. Every tribe believed itself to be self-governing. Some use the term sovereignty, some use whatever term was the term that was meaningful within their native communities. But what we meant by that was states stay out of our internal affairs. One of the challenges through this time has been in mediating, shall we say, defining and mediating what self-governance means to us, what are the principles that guide us, what are the behaviors that are consistent with the messages of the ancestors guide us right now, must guide us right now. And so self-governance is still a highly meaningful matter within our communities. Defining what that means and what systems will accommodate both our the aspirations of people of various generations and various exposures and experiences within however you define your tribal nation, and what will the external folks, the state, federal, and local governments, acknowledge, and what will the courts say you have a basis for battle about.
Thank you, and thank you so much for your incredible work. You actually mentioned the various type of work that you were involved in over the course of 33 plus years. I'm curious, as you look at the landscape today, what would you identify as the most pressing issues? We have a lot of folks in the audience that are working, or law students that are hoping to work on issues. And so I'm curious, from your view, what's the most pressing?
All of it. I don't purport to speak for any other nation. I don't purport to speak for my own nation, much less any other nation today. I have a little bit of insight as to what I think's going on within my own community. And I would say that, whatever's going on in the world is going on for us. We don't know if there's going to be an Eastern Long Island after a period of years, not many years. Is it 2040 or 2050 when our area will be below water? My husband and I recently built a new house, and I had a teeny tiny house kind of down by the water, and we decided to replace, and where are we going to build the new house? I said, we're going to build up land. We're not going to build on the water. I've already had a flood down there. So climate change is our issue. Health and safety are our issues. Drugs are our issues. Missing and murdered Indigenous women and others is our issue. everything that's an issue for anybody is an issue for us. So in terms of your skill development, I've been on a board you saw me sitting here very rudely a few minutes ago. I was on a board call. I'm a vice president of an organization called First Nations Development Institute, and we endeavor to funnel some technical assistance, but more we've endeavored to corral money from the big philanthropic organizations and get them to funnel money into the communities. That means we need people who know finance. I mean, I'm sitting here I spent an hour going over our budget sheets. What's our endowment look like? Where are we getting our funds? Are we in the right bank? So basic banking skills are needed. Basic tax skills are needed. All the skills that any of you will use with any other client are needed. However, we also would hope that you would use your skills in a way that does not destroy a people or what do we got, about 600 tribes now? What? 574 is the number of federally recognized tribe. But remember, law on our terms. There are still many communities that believe themselves to be communities worthy of the imprimatur federally recognized, or at least communities that know they have cultures that they have to figure out how to preserve, even without that label. They have communities that they have to keep healthy. They have communities that need support of, again, any legal. Now, we're all facing, those of us who are lawyers in this room and familiar with Indian law, know that we're sitting on pins and needles, kind of waiting for the Supreme Court to drop one on us in the matter of Brackeen. 1978, Indian Child Welfare Act. One of its great champions is sitting in this room right now. NYU class of 71, is it? Bert Hirsch. We know that right now, that was a wonderful law. It said, and I have a friend who used to say, this isn't about child welfare. This is about sovereignty. This is about our people's right to know, to capture our own children, to bring them home. Now we're hearing lots about the boarding schools, and we talk about bringing them home, the efforts to bring the children home, or at least identify the graves where many of them are, those children taken away are buried. But it's really important to bring them home. And I can think of the first time, now we at Shinnecock, not being federally recognized at the time, but nevertheless benefiting from New York state law, which did adopt its own Indian Child Welfare Act, and did say that we had a special status, we as Native nations had a special status in the courts when one of our children was coming before the child welfare system. We had a right to go in and say, either we'll take jurisdiction or you proceed with jurisdiction, but these are our kids and we're going to participate in what happens to them. I recall one case in which it was determined that nobody on the territory was going to be able to take this child. And there are many details about why. But I was so delighted when about 10 years ago, I asked an older relative of that child, what happened? They said, oh, they were here last week. I said, yes, we did not lose our child. We did not take jurisdiction. We did not place that child with a family member, but that child's name went in a draw in our tribal office, paper boxes though it has. But we knew that child was ours and would one day be able to stand up and say, I am a Shinnecock and you are to be recognized. So Brackeen's I'm sure that'll be talked about later. Matt, one of you guys is going to talk about Brackeen. Big cases. important cases. In addition to basic climate change issues, all sorts of energy issues, all sorts of broadband issues, access issues, health care. You know, we're a people on the water, and it was said that over time we were whalers, ocean whalers. And we also had offshore activity with the whales. That fat has omega-6s, healthy stuff. The cranberries are gone from my territory. Most of the berries are gone from my territory. The things that are healthy. And so we've got diabetes, and we've got heart disease, and we've got all sorts of diseases of lifestyle. And so it's important that we, as lawyers, protect the lands, protect the access to those things, those foods that are important to us. And it is important, and so maybe that's a land claim type thing or an access type thing. Access wherever the berries may currently grow, even if not technically within the tribal territories. The traditional cultural properties. We need to protect those things to keep us healthy. I'm sure I've forgotten half of what I was going to say. So,
Thank you so much. You've mentioned how important the law is in the work that you've done, but I'm curious on your perspective how the law fits in with other tools for sovereignty. And you mentioned your work, for example, with the First Nations Development Institute. Can you speak maybe to that or to other ways that you've seen sovereignty be advanced in addition to or maybe even alongside the law?
well, when you asked, you did give me some of these questions in advance, and so where does the law fit? Well, whenever you're talking about a government, you're talking about the law. So whenever you're talking about a native government, you're talking about the law, or the people encompassed by that native government, you're talking about the law. Law is always present. Law is always present in everything we do. Native people probably have to be more familiar with the law than most of the citizens. I mean, let's not talk about this country's educated citizenry right now. This United States' educational status. You know, these days everybody's an expert on the Second Amendment and rights to privacy and et cetera. But natives really do have to be very familiar with the law. We have to be we are in the process of looking at, developing our own court system, whether we're going to, and even identifying certain behaviors. Are these against our law? Are these to be adjudicated within our territory, externally? In New York State, or not New York State, the 25 U.S.C. 232, 233 are federal laws which pertain to New York State, which give civil and criminal jurisdiction to the state of New York over certain matters, not against the tribes. But our people know this stuff. You know, how many everyday citizens talk about the law, talk about jurisdiction, talk about governance in the way that affects every step you make, talks about is it our right to choose our school district? Is it our right to stay home if we don't like the school district? Or you're going to be prosecuted for not sending your kid to school because of whatever you think is wrong with the school system. We face those on a daily basis. So that's life. Life as an Indian is life in the law. First Nations, let's see, we're about 40 years old, a little bit over 40 years old now, I guess. And we came together, I was not the founder, but an early on board member. again, to try to educate the philanthropic community about the needs of Native people and a whole array of issues. We started out with a land consolidation group, and we started out and we moved into many, many areas very quickly. I was a lawyer on circle banking. Do you know what circle banking is? Do you know what micro enterprises are? Well, somebody took I guess it was Grameen Bank in India, used a model of kind of circle banking where the community circulates that money, starts up the business. So I started off with a Lakota fund. We got a grant from Ford Foundation. I was a lawyer, or the lawyer on that one for us. We got the Lakota fund started, spun it off. I'm hearing right now that they're trying to do a California tribal fund. We have been taking the money in at First Nations, but it will soon go out for that locale. So we have been a voice to bring money in and then let the local communities or regional communities at least take that money back and do as is appropriate for their communities. So that's some of the lawyering, just basic transactional stuff, documents and contractual relations. Again, I can't think of where, it is frustrating to go to a court, a traffic court, and have a colleague say, well, are you guys citizens or not? Well, depends on whether I want to be arrested or not. You've written that I'm a citizen of the Shinnecock Nation, and I kind of call myself a dual citizen, a citizen of the Shinnecock Nation because I live there and have voting rights there. By the way, I didn't have voting rights when I became a lawyer because I'm a girl. And at that time in our community, women did not have vote. Women didn't have formal voice, but women had power. And this was one of the big disputes that some of the other women, now I went to Smith College, home of Betty Friedan and Gloria Steinem and those icons of women's rights. But I got it. There are other ways of wielding power. And that little game the guys played, is this being taped? That little game the guys played about going to their meeting and deciding what they were going to do was a game that some of the women laughed at and did not think it was as important. It quickly became the decision of the community. Well, actually, I had this conversation with someone just the other day. I said, look, I'm not sorry. I'm the woman who said, no, you do not go to court to have their court tell us what we need to do. We need to make this decision. And sure enough, that's what happened. And yes. And then I remember the tribe meeting where the men turned to me and said, well, it says in the state law that the men make these decisions. I said, so that's the state law. That's not our law. Law on our own terms. We decide, at least as far as internal affairs, what's good for us. And so women do vote, women do run for office. Matt told me, Professor Fletcher told me today that one of his interns was my cousin who's not here yet, but who is a tribal trustee right now, a duly elected tribal trustee right now, has been an attorney for the tribe. So this is, again, the law is all we do. There's not, in the early 90s, we were able, before federal recognition, we were able to establish a health center on the territory. I don't need to take credit. I just need to say, yeah, I did the advocacy and the lawyering on that, Everything we do in building a society has to do with using the law, but it is guided by other forces. It is guided by messages of the ancestors. It is guided by messages from the earth around us.
Thank you. And so I want to kind of shift to, you mentioned that you did spend some time here at NYU and graduated in 1974. I just, for the benefit also of me as a student here now and for the other law students in the audience, can you talk about what was or wasn't available to you on campus to engage issues that were important to you in your community, and how you would recommend or any insight you have for current students in doing the same today?
Well, I'm delighted to hear that you've had an ELSA chapter before. There was I'm not sure which year, was it in my last year or the year before, that S. Bobo Dean was the Indian law professor here every other year. I didn't get to, did you take Bobo Dean's class, Bert? It was after you, so it was sometime, it was probably in my third year, that's our last year in law school. It was probably in that year that he came. He was a Washington law practitioner, a big deal practitioner, and I couldn't fit him into my course schedule. It just wasn't working for me. I actually, after law school, I was working, I came back, I had to matriculate to take his one course. I had to matriculate as a master's student to come back, and I didn't want a master's in law, I just wanted his course. So I came back, paid all his tuition, came back and took his course. So yeah, I have had formal training in Indian law, but it wasn't generally available then. It was, I recently realized that Peterson Za, who was a president of the Navajo Nation, but prior to that was, I guess he was the founder of DNA, the Navajo Legal Services. Pete recently died. Pete actually recruited here at NYU. I think he came 2 years to try to recruit for summer, and I turned him down. It wasn't in my desire at that time to go to Navajo. Actually, I turned Navajo down 3 times. I'm just an East Coast kind of kid, So I didn't go out to Navajo. But so I say that to say that NYU did, at a point in time, decide to reach out to or make its recruitment space available to someone who could offer opportunity for on-the-job experience in Indian law. My experience, as I said, came from home, came from having to work with the people in my community on whatever we needed, whether there was a coalition of Eastern Native Americans that moved together. Some were treaty tribes or acknowledged treaty tribes, some were not. In our own case, we appeared as federally recognized on lists in 1915, but suddenly they're not there in 1930. This is the craziness of Indian law. Where'd we go? I mentioned the Montaukets. They were where they were in Montauk, for those of you who know Long Island, and suddenly the railroad guy wants to clear title to lands he had acquired, and told the people sitting in the room, they're extinct. So their descendants are now still in the fight to have themselves affirmed as a Native nation first within the state of New York. And I can't think of what doesn't touch. First Nations, again, started doing technical assistance, but increasing its efforts and its visibility as a place that could corral funds. Funds are needed. we were looking at our balance sheets today and seeing how much money came in during COVID. But it's never enough. It's never enough. There are lawsuits all the time concerning the Congress will appropriate a certain level of funding for the Indian Health Service. Never comes in. Never gets there. You never quite get what you need. Some of the tribes find themselves in conflict over which of the tribes should get what money. It's often, if not always, been a fight over a small and ever-shrinking pie. Who gets what size slice of that pie? And that pits us against one another, as well as against the general population, as well as against those who want us extinguished altogether.
Thank you. And as we wrap up today, I just have one last question for you, which is, you mentioned 33 plus years of work, and you're still doing the work. You just got off a board call for the work you're doing. How have you sustained? How have you remained able to do this work for so long? I'm just curious.
It's family. Sometimes it's even fun. I believe that one must do justice, but also have joy in one's life. I'm a little sad. I just lost my husband. He was NYU 72. So I'm a little sad right now. It's nice to have a partner in doing that work. If you don't find that special partner, there's always friends. There's always people you can march with and laugh. I only join boards where laughter is allowed in the meeting room. You don't laugh. What's the point? If you can't see that there is sunshine over that, and behind that smog. And that's part of what it's all about, in terms of a sort of a spiritual, personal centering of self. Whatever, however bad it is, and that's usually the people you're working with, or the issues you're working on, or the government that's offensive. You got to find something for yourself that sustains you. You got to make a commitment to your own health. You got to make a commitment to the people you love, or whose future you have taken as your calling. So, it's really hard, but it's living. You go through it in family, you go through it in small group family, you go through it. What do I say? I actually wrote an answer to the question. Well, how do you sustain yourself? Family, personal health, water. I live on the water. Go to the water all the time. Pray at the water, swim in the water, pick up rocks in the water, throw it, put an adversary's name on that rock and throw it into the water. Whatever you got to do. But live life with joy as you pursue justice.
Live life with joy as you pursue justice. I can't think of a better way to end our conversation today. Thank you so much for your time, and if we could all give a round of applause.
Thank you.
And for folks in the audience, we're going to take a brief break, and we're going to get started right around 2 p.m., so feel free. Again, the restrooms are right outside, straight down to the right, across from the elevators. And thank you again. See you soon. So we're going to begin with our first panel. So today, this first panel is going to be on tribal jurisprudence. We will discuss on this panel the origin of tribal jurisprudence,
tribal constitutional law, understanding of rights, treaties, law, and nature. We have some great folks with us here today. First, we have Professor Amanda White Eagle of Ho-Chunk. Professor White Eagle serves as the clinical fellow for the NYU Yale American Indian Sovereignty Project with more than 15 years of experience in tribal law. She provides advice and counsel to the Ho-Chunk Nation as a senior tribal counsel. Previously, she served as a judicial officer for the Ho-Chunk Judiciary, as well as the tribe's Attorney General and executive tribal court judge or justice to tribal governments throughout the United States, including the Wampanoag Judiciary, Prairie Indian Community Court of Appeals, and Santee Sioux Nation Judiciary. Previous experience includes serving as the state of Wisconsin's County Court Commissioner. She's admitted to the United States Supreme Court Bar and the U.S. Federal District Court, Western District of Wisconsin, Ho-Chunk Nation Bar, Wisconsin-Madison with liberal arts, Ho-Chunk Bar, and attended the University of Madison, Wisconsin with liberal arts degrees. Professor White Eagle will be moderating our panel with our two panelists. First up is Stephen Paul McSloy, we'll call Steve. He's a partner at Carter, Ladard, and Milburn in New York City. He is previously general counsel of the Oneida Nation of New York and Turning Stone Casino Resort. Steve has also taught American Indian law at New York University, Fordham, Cardozo, St. John's, Syracuse, and Columbia Law. Specializing in American Indian law, Steve has worked on some of the largest, most complex financial transactions in Indian country. He's published 8 law review articles and is a member of the United States Supreme Court Bar, the Oneida Nation Courts, New York, and the New York State Courts. He has spoken on Indian law issues at Harvard, Columbia, Yale, Cornell, UPenn, and NYU, as well as at numerous bar associations and other conferences. Steve received his JD from Harvard and BA from NYU, and was a member of Phi Beta Kappa. Welcome to you, Steve.
Thank you.
And we also have here Professor Matthew Ellen Fletcher. Matthew is the Harry Burns Hutchins Collegiate Professor of Law at the University of Michigan School of Law. He teaches and writes in areas of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, constitutional law, federal courts, and legal ethics. He sits as the Chief Justice of the Grand Traverse Band of Ottawa and Chippewa Indians, the Pokagon Band of Potawatomi Indians, and the Porch Band of Creek Indians. He also sits as the appellate judge for several other tribal nations. He's a member of the Grand Traverse Band, and Professor Fletcher graduated from the University of Michigan Law School in 1997 and the University of Michigan in 1994. He's married to Winona Single and is a member of Little Traverse Band of Ottawa Indians, and they have 2 sons, Owen and Emmett. Welcome to our panelists, and we're very much looking forward to this conversation. I'll pass it over to you, Professor White Eagle.
Great. Is everybody able to hear me all right? Great. So we're going to divide today's discussion into 4 parts, but first we provided some introductions, but I'd like to hear from each panelist a bit more about yourself, your work with respect to tribal law, and why this work is important to you. We'll start first with Professor Fletcher.
All right. Thank you. I come to this work as an academic and a tribal judge now, but I started my legal career as in-house counsel for ultimately 4 tribes. And there's really aren't that many people who became law professors and academics who came through that, who practiced law for Indian tribes in-house. And it's sort of an unusual kind of route, and those of us who do this sort of work are sort of unusual legal scholars. Somebody who works in-house for an Indian tribe is what lawyers often refer to as a generalist. We take any case or any matter that comes before us that our client sends our way, and it could be literally anything. I had tax cases, child welfare cases. I did financings with outside counsel like Steve. I did a lot of litigation in tribal court. I did a lot of stuff where I sat around reading corporate board practice manuals to try to figure out what my client was doing, because weirdly enough, tribal governments are often organized like corporate board of directors, and that's totally indigenous. So it's great. It's a great experience, and you really get to see your clients all the time, which is both a good and a bad thing. You get to see the people that you are working with, working for, and you're constantly reminded why you're doing this work. And it's really, really hard. It's probably the hardest job in Indian law is to work in-house for an Indian tribe. So I say that with only having like 2 different kinds of jobs in my entire life, so I'm talking completely out of school on that question. But I think that's my background. I now became a law professor partly because my wife, Winona, went to Harvard, and all of her friends went to Harvard who do Indian law, and a bunch of them became professors. And I kind of thought they were all a little bit like dumbasses, and I thought I can do this. So I decided to do that. I became a tribal judge a few years after I became, actually before I became a law professor, but I didn't have any cases until 2005 when I was living in North Dakota. And I will actually talk about one of those cases when we get to sort of the meat of the day, but I'll stop right there. Thank you.
I should start by saying I'm not a native person. I'm just Irish German Catholic from Long Island. And I began an accidental career in law school, in Indian law in law school, because we wanted to write an article with some friends. None of us had gotten on Law Review, and so we decided to write something for the Harvard Civil Rights, Civil Liberties Law Review. And in our property class, we had done Johnson v. McIntosh. So all of you who've had first-year property know that case. We said, well, that seems like an interesting thing to write about. It's kind of civil rights-y and all that. And then on one of the breaks, probably appropriately was Thanksgiving, there was a symposium up at Columbia. This is in the 80s. And that's when I first heard the S word, sovereignty. So I went back and thought, no, it's not a civil rights issue. It's this whole other thing. So we wrote this article. But then I went off to be a corporate lawyer at Cravath. And as it happened, and Bert knows this, the Cravath represented pro bono the Oneida Nation, which Margarita talked about, on its land claims. And one thing the big firms do, or at least Cravath does, is for any large litigation, this was already on cert, they have the settlement talks handled by the corporate lawyers, which makes sense because those are the deal folks. And if you're this way the litigators also never have to be nice to each other. You're going to keep fighting, and this other group of folks can be the negotiating team. So I got, right from the beginning of my career as a lawyer here in the city, all this pro bono work working for the Oneida Nation, working on trying to settle their land claims, and it never did. Fast forward a few years, and gaming comes in, and now Indian nations are in business. And all of a sudden they have 10,000 new best friends, all these lawyers and bankers and all that. But having already been working pro bono on kind of on the right side of things, that began my accidental career in Indian law. I'm happy to be back here at NYU. I graduated here a long, long time ago from the college. And then years ago, and I mention this partly because of what was said before about reviving NALSA here. Back in the day, the NALSA folks wanted to have an Indian law class. So they got together with the Review of Law and Social Change, which you see as one of your sponsors today, and they had a symposium like this. And none of the speakers knew that that was actually also the covert audition to be the Indian law professor here. And I got asked, but then I got asked, is there anybody that you might want to teach with? And I picked up on that right away. And I said, well, I know the leader of an Indian nation, Ray Halberter, the leader of the Oneida Nation. They kind of nodded. And I said, and he went to Harvard Law School. And they said they really nodded. So in the 90s, because of the activism of Review and Law Social Change and NYU and ALSA, we had an Indian law course, Ray and I, for several years here at NYU. And I did publish that article it's like 30 years ago. Yeah, it's in the Review of Law Social Change 2003. It's my big, when you're a law professor, your first article, you write absolutely everything you know. So it's in there. It's called Back to the Future, Review of Law and Social Change, whatever volume that was. And since then, I've continued this accidental career representing Native nations, representing banks, others involved in doing economic development, business, finance, all just some form of contracting with Indian nations, which because of Indian law, as we'll talk about, it can be very complicated and needs experts.
Thank you. So I'll also just add, First, Ho-chunk rajra wipamakadenga hingaide, hunchiki karachwa anje, niokwani eja hachiaje, egi wadaje, lanapega eja hachiaje, egi wadaje. So just really briefly, I know it's important for me to introduce myself in Ho-chunk. I'm originally from Wisconsin. All I did was indicate my name, my clan, which is a Bear Clan. Where I live and work is Black River Falls, Wisconsin, Neokwani. And then where I live and work here, there isn't a Ho-chunk word for New York City, so I have coined it Lenapega. So that just really wanted to thank you today for inviting us and this panel. A little bit of background, I did work for 15 years, more than that, for the Ho-chunk Nation as an in-house counsel. Kind of an odd trajectory to end up as the NYU Yale Clinical Fellow for the American Indian Sovereignty Project. Did want to talk really briefly about that. It's relatively new. It's been in existence for the past 2 years. The project has worked on 5 amici briefs before the United States Supreme Court, ranging from cases that weren't accepted, like Penobscot case that was from the First Circuit discussing treaties or treaty substitutes, as well as cases like Brackeen, Dinesh P. Castro Huerta, and most recently the Navajo Nation case. We also have a tracking provision where we track cases that are percolating through the circuit courts, and we have students working from both Yale and NYU on those matters. Additionally, we're also coding tribal constitutions with Northwestern University. So we have a lot of involvement here with students and really hoping to capitalize on NALSA's involvement and hopefully get more and more individuals interested in that. So just wanted to also provide that little bit of introduction from myself, how I ended up in Indian law. Essentially, I graduated and was working at a record store, the Banana Republic, in my tribe's bingo hall, and I thought something's got to give, and that's how I ended up in law school. And as I was paying for law school, I thought, darn, this stuff is expensive, and my tribe said, hey, we'll pay for it all. You just have to come work for us for a couple years. A couple years turned into 15. It has been an amazing experience, but it has been a little bit of a unique trajectory because now I'll be moving on as a teaching professor as well as running a center elsewhere. And so it's been an amazing experience. So as I promised, we will be talking about we'll divide this into about 4 different issues, talking about historical context, contemporary tribal legal systems, emerging issues, and how to engage in this work. So the first historical context discussion is a really long multi-part discussion that I'm going to read, and then we're going to break it down a little bit. So first, law schools often teach a singular progression of legal and social history of rights, but we know that there's a lot more to learn. What can you share from your work about the historical shaping of rights and legal standards in respective tribal contexts? What are the animating factors? For example, how does traditional law, tribal common law, play a role in tribal jurisprudence from your experience? How did nations blend ancestral traditions, and often shaped by colonization and removal? And what can we learn from how tribal nations shape their legal systems and interact with society? And for those that have worked across nations, can you identify any uniting factors or lessons we can learn on the aggregate? So I don't expect you all to remember all of those. We can come back and I'll touch base, but I'll start off with Steve.
Well, Ed had asked me to give a kind of brief overview of Indian law, which I try to do in 2 or 3 or maybe 5 minutes. Professor Benelli and I, it takes us 13 weeks, 2 hours a week to even try to get through it. Some of you may know this well, but we thought it would be good context setting to just set out some of the basic principles. So we start out with the idea, of course, that Native nations are nations. Their relationship is with the United States itself, nation to nation. Originally, that was all about treaties. Originally, that was a function of international law. Native nations are not part of we the people. They're in the Constitution as subjects, but not part of the organic nature of what the Constitution sets out to do. They're not part of federalism. They're not states, they're not towns, they're not counties, and they're not part of the constitutional structure. They're not part of separation of powers. They don't have a federalist role. There's no supremacy clause except to the extent that the federal government tells the states what to do or how to act about Indian nations. So that's some of the good original news. But then you get the United States law. And what does United States law say? That there is no sovereignty unless the United States recognizes it. And nobody knows this better than the Shinnecock people, who literally hung out with the Pilgrims and only were recognized by the United States in, 2010. There's also no land unless the United States recognizes it by treaty or law. There's land that people lived on literally since forever. But is it Indian country? Is it a reservation? Even that word used to come out of the treaty idea that an Indian nation might say, okay, you guys can have this peninsula or you can have that valley, but we reserve all the rest to ourselves. We're not giving that away. We're not selling that. We're not alienating it. It later became this idea, and certainly in the popular conscience, that it was reservations by the United States to put the Indians here and there, which, of course, did happen. And then Congress ended all treaty making in 1871. There hasn't been a treaty since then. Because they're apart from the constitutional structure, the Bill of Rights does not apply to tribal governments. The famous case of Martinez, where I used to start the course with this. The Santa Clara Pueblo said that if you're a male member of the tribe and you marry outside, your children would be members. But if you're a female member of the tribe and you marry outside, your children are not members. It went all the way up to the Supreme Court, and none other than Thurgood Marshall said, no, that's perfectly all right. That's exactly what sovereignty is. They are not protected by the Bill of Rights because that's living under their own law. That's how they chose to govern themselves, and it's not for the federal government to interfere with that. Native people are also not a racial category. If an Indian nation puts out a job ad and says only there's a preference for members of that nation or even preference for Indian people, that's perfectly legal. The Supreme Court has no problem with that. Now that, of course, is what is under attack in a different way in the Brackeen case. The challenge in the Brackeen case is that by having this idea that Indian children can be specially treated and that tribal governments can have jurisdiction over them, some have said, the plaintiffs in that case say, that is racial discrimination. The key issue in this structure, in terms of sovereignty, or relative sovereignty, I guess at this point, because the United States doesn't seem to be going anywhere, is that there is no state power over Native nations. There's no state law, there's no state taxes. The relationship is federal. The federal government says something, unfortunately Indian people will have to live with that because the era of real international law or diplomacy or war has passed. But this is why when you go to an Indian reservation, you'll see often a smoke shop, no state tax. A gas station, no state tax. The Supreme Court ruled in 1988, yes, they could have casinos because the only law, there's no federal law against casinos, there are only state laws, and they don't apply. Indian nations have got into all sorts of ventures where the freedom from state regulation, freedom from state tax allows for an economy to grow. Last bit. Everybody here has had civil procedure at some point? Right, so remember the Erie case, the idea that there's no such thing as federal law, federal common law? Well, Indian law is one of the very few things that is federal common law, meaning it's made up by judges. Again, it's not part of the Constitution, it's not part of the structure, so it's whatever the Supreme Court says. And Justice Brennan had given us many years ago the Brennan Rule, the most important constitutional principle of all, is the ability to count to 5. Whatever gets 5 votes, that's the rule. The Supreme Court is not infallible because they're final. They're final because they're the other way around. They're not final because they're infallible. They're infallible because they're final. Once the Supreme Court says it, it applies to every Indian nation everywhere. Brackeen is an adoption case. It's a family court case. It is now up before the Supreme Court, but the principles will affect every one of the 574 nations, whatever they say. So what are some of the things that have been said or held as a matter of this federal common law about Native people? First is that they are, quote, domestic dependent nations, which if you think about it is sort of like a triple oxymoron. How is a nation domestic? How is a nation dependent. They are subject to the plenary power of Congress. Whatever Congress says, the Supreme Court will uphold. If it wants to put tribes out of existence, there was a period in the 1950s where Congress said that tribe doesn't exist anymore. The Supreme Court said, yeah, fine. The plenary power of Congress. They have no longer an international treaty relationship with the United States, but are subject to what Justice Marshall had called the guardian ward relationship. The relationship of the United States to an Indian tribe is like that of a guardian to their ward. Now that's dressed up as the trust relationship, and some might argue that it's better and milder, but it is still part of this idea that Indian people and Indian nations are still in school, are not competent. The other people who are wards are children, people under mental disability, and Indian nations. As coming out of this, there's a somewhat helpful thing, and this is the title of Matt's paper, Canons of Construction. The Supreme Court has said that when we interpret treaties, when we interpret congressional statutes, you do that as the Indian people would have understood at the time. There's paternalism in that, but there's also potentially benefit. The Supreme Court has also said, and this leads into the next panel, that an Indian nation has no criminal power over non-Indians. None. Zero. The case came up, it was actually out of Washington. A non-Indian had punched a tribal cop. I don't know where in the world you think you can get away with that, but on an Indian reservation you can. They cannot try you. They cannot imprison you. And Indian nations have almost no civil power over non-Indians without their consent. It's 3 weeks of class to talk about Montana, but let's leave it at almost no civil power without consent. The current legal battleground, I'll finish with this, is, given who's on the court now, a battleground over text, or the lack of text in treaties or in law. If there's some good text, Justice Gorsuch will say, yes, half of Oklahoma is still Indian country, because that's what the treaty said. But then Justice Kavanaugh, in the most recent case, will say, yeah, but there's no federal law that says when non-Indians go onto the reservation, they are subject only to federal law for the crimes they do. There are federal criminal laws. We know they're not subject to tribal law. So they said, well, that might be Indian country, but the state has power over all the non-Indians there because the reservation is part of the state. Because there's nothing federal that says otherwise. What it comes down to, in particular that case, that was Castro Huerta, which was last term, is what is the backdrop? Justice Kavanaugh would say, if you can't find jurisdiction, it's in the state. An Indian nation would say, no, it's in us, or it should be part of this trust relationship that we have with the federal government, and the federal government should be protecting our sovereignty where you've taken away our power to protect our own sovereignty. And, was that 3 minutes, 5 minutes? That's good.
You know, that was impressive. It was a little under 9 minutes.
Okay.
But that was like an entire semester at a minimum. So transitioning a little bit from that amazing, quick sandwich of information, how do you believe that this plays a role in tribal jurisprudence from your perspective in terms of customary law or traditional law?
Me?
Yes.
Okay, so yeah, let's talk about tribal laws, tribal customary laws. So, you know, the United States, in the exercise of its plenary powers over Indian affairs, has sort of dictated terms to tribal governments as to what their powers are and what they can do as tribes. And by dictate terms, I mean basically until the 1970s and 1980s, the United States ran Indian reservations. As soon as reservations were established, the Office of Indian Affairs, or the Department of War or Defense, would come in and set and decide who was going to run the reservation and under what laws. They began this in the 19th century by adopting law and order codes, by creating courts of Indian offenses, appointing Indians to positions in the judiciary and as police/prosecutor. By the way, that's conflict of interest. You're not supposed to be a cop and a prosecutor at the same time, or a judge at the same time. But I think that was pretty routine under the thumb of the Bureau of Indian Affairs. That was basically the law for the latter half of the 19th century in Indian country until probably close to the last few years, as a practical matter. Tribes began to exercise self-determination for the most part in the 1970s and 80s. unless the tribe wasn't federally acknowledged, like Shinnecock or my own tribe, Grand Traverse Band, until the 1980s or later. And we basically inherited these laws of the United States that the colonizer had imposed on us. And we took them and accepted them effectively. Tribes in Michigan would routinely borrow the criminal law of the state of Michigan, just pass an ordinance that was 1 page long saying until we adopt our own criminal code, we're going to use the laws of the state of Michigan. And that was pretty routine. It still is routine with tribes throughout the United States. It's easy to do that, especially when you desperately need a code, and it's really, really unfortunate that if you stick with it for very long, because there is a fundamental philosophical difference between United States, federal and state governments, and tribal nations. I mean, absolutely fundamental. If you look at the U.S. Constitution, the Declaration of Independence, Bill of Rights, what you're going to see is a top-down hierarchical government where the political theory of Western nations is that there has to be this sovereign entity, a leviathan, that owns a monopoly on violence against its own citizenry. And the reason for that, ostensibly, which is empirically false, is that humans are so selfish, violent, ruthless, and competitive that we will be in a war of all against all in this state of nature without a government to control us. This is the American political philosophy writ large. That's why we have a Supreme Court. That's why we have a national government with a Congress with plenary powers over Indian affairs and other areas of law. So tribes are not like that. Indigenous communities were much more vertical in their governance. And, we can talk about that structure. We actually see it a little bit through the cracks in Indian country. But, our governments are hierarchical top-down governments for the most part. There are some Haudenosaunee nations that have never really bought into that American bullshit. But they also struggle just as much as a consequence. They are punished by the United States for not playing ball. So my paper is a lot of my scholarship is designed to try to tease through what's going on in Indian country with our governmental structures, our justice systems, to try to bring out some of our customs and traditions, some of our political philosophies. So one of the ways I do that is through my judging work. I also am a scholar. And in the most recent paper, if you want, that is, I guess, ostensibly the source of my remarks today, I propose an indigenous canon of construction for tribal judges to use when reviewing acts of the tribal government, laws passed by the tribal government that have a strong federal or state government flavor to them, to try to lessen some of the impacts that these very much non-Indian, non-indigenous laws have on the lives of Indian people. I'll stop right there. I'm speaking at an extreme level of generality, so I'll drill down a little bit later.
So this is a good transition to contemporary tribal legal systems. So we've spent some time laying the historical framework, and now let's turn to contemporary tribal courts and legal infrastructure. Again, another multi-part, so I'll read the four, and then we can go back and talk about them individually. What are the characteristics of the tribal judiciaries and legal systems you work with or within? What are the central values we see tribal courts holding? How is this distinct from Anglo-American legal structures? What can the broader legal community learn from tribal legal systems? And then how is tribal legal jurisdiction expanding, or is it contracting? And what is leading to those patterns? So
I think you want to lead on that.
That's fine. I sit on 13 appellate courts, and I've worked over the years in my real practicing life for 4 different tribes. Every one of the tribes is a tribe that adopted a top-down hierarchical structure. we don't have dictators in Indian country, but what we have are people that tend to be elected into positions of power for periods of time. Anishinaabe leadership, the Ogama from way back in the day, the people selected to go negotiate with Andrew Jackson in 1836, for example, from northern Michigan, they were not elected officials. They were chosen in a community event, a series of them, to speak on behalf of the community with extreme limitations on their abilities to speak and their abilities to bind the Anishinaabe nations in Michigan to a treaty with the United States. And they were chosen for a particular purpose. They were not elected, and so when that purpose was concluded and the treaty was done, their power evaporated completely. And there was no figurehead or leader that anybody could turn to say, well, that's our president, or that's our dictator, whomever. All that stuff went away as soon as the treaty negotiation was over. And if another crisis or event occurred, then there would be a discussion about who should be a part of the leadership that would respond to it. And that's traditional, classic, customary Anishinaabe political leadership. And, that's all gone now. So we elect officials. We tend to elect people, at least in my tribe and the tribes in Michigan, based on how, they get the most votes based on how many relatives they have. There's no special skills that are required to be tribal leaders. Anybody can run as long as they're of a certain age, and probably if they don't have a felony on their record. We end up getting a lot of people elected who probably shouldn't be leaders. We also get a lot more people elected who probably would never be elected in any other election in the United States except for their tribe's election, and they're amazing at it. But they are amazing in a certain way that probably is foreign to the way that the people of 1836 and Anishinaabe communities would have understood. Similarly with judges. Judges started out in tribal communities in Michigan as being non-Indians, non-lawyers. Eventually, enough people like me went to law school, became lawyers, tribal members, started to fill the roles as tribal attorneys and as tribal judges. That doesn't mean there's anything special about them. There's plenty of legal scholarship out there saying that Indian people who go back to work for their own tribes have been indoctrinated by law schools, that they've accepted the adversarial process, that they compartmentalize their thinking, they've lost their customs and their traditions and effectively their languages. And I know at least one person told me that law school is like boarding school, and that's not true at all, but there are some impacts to going to law school. So I've learned how to manage the adversarial process as both a lawyer and as a judge, and I've had to try to unlearn some of that for purposes of the work I do as a tribal judge. All the cases I handle are totally part of the adversarial system. The structure that tribes have adopted all comes from outside. We have a great story in Michigan for the Anishinaabe called The Trial. It's a traditional story in Adezokan that starts with what the trial is. It was a murder trial. Everybody in the entire village, people from outside the village would come into a giant longhouse effectively. We didn't have it, it was a circle, so we'll call it a giant, it's a longhouse. And everybody in the community was both the judge and the juror. There were no conflicts of interest. The whole thing was designed to involve everybody as part of this really important murder trial. And it's a wildly varying story than what we have now. And what I've tried to, you really can't get away from that unless you get rid of your judiciaries, and I'm not advocating for that. But one of the great things that tribal nations in Michigan and elsewhere are doing, they get this originated with Navajo, is alternative dispute resolution mechanisms like peacemaking or circle sentencing, where certain kinds of crimes or certain kinds of cases are diverted into a non-adversarial structure. Call it whatever you want, but usually involves a lot of circles, a lot of talking, and no arguing. And we're starting to learn how to do that in a way that is helpful to a community. We're starting to bind communities together that were fractured and fragmented. People had been moved out of their reservation homes generations ago, are starting to come back, and they're learning how to live in an indigenous community. slowly but surely. This is not something that will really end up being any kind of conclusion, probably even in my lifetime or even in my kids' lifetime, but it is a long-standing process of trying to restore the community. So it's a multi-layered effort. Different tribes are trying different experiments to see what works. They're watching each other. We're talking to each other at meetings like this and trying to figure all of this stuff out. All right, I'm done. Just rambling.
One of the ways that tribal court systems come into the economic realm is because it's bigger than the United States. It's the thing behind the United States, the thing behind the doctrine of discovery, the thing behind colonization is capitalism. And what capitalism wants is to know it's going to get its money back. And there are countries of the world that can't borrow a nickel because they're not stable. Their governance is not clear. There's no intelligible dispute resolution system, whether they do it culturally in their nation or they adopt a Western-style system. It's all corrupt and broken, and so they can't borrow a nickel. When the United States buys tanks, it waives its sovereign immunity, the same as an Indian nation would have to do. When Ukraine buys those tanks from us, it waives its sovereign immunity because everybody wants to know that the contract, whatever it's about, will be upheld. The specifics of Indian law come into economic development as risk factors. What will the court, if the first question always is, will the courts uphold a waiver of sovereign immunity? The answer is yes, but bankers don't know that. They're busy lending to America, to Ukraine, to Saudi. They don't really care that this is this nation's first tribal bond deal or first bank borrowing. They want to know, are they going to pay us back? In the story out of Navajo, we were involved in a big bond deal, and President Shirley had 2 terms. And under Navajo law, Navajo written law, you could only have 2 terms. Another president was in office at this time. But Navajo doesn't have a constitution. They rejected the IRA. So there's no higher law. There's just a 4-volume, maybe it's more now, set of laws. Looks like the kind in the library here. But the very first section says that the ultimate law of the Navajo people is the traditional law, the customary law. And it can only be known in the Navajo language. The Navajo code is in English, but the traditional law can only be known in the Navajo language. And President Shirley decided to run for a 3rd term right in the middle of this bond deal because he said, well, under the traditional law of the Navajo people, the people decide who their leaders are. And so that trumps any idea of term limits that the Navajo Council and people had voted on. And so in the middle of trying to sell these bonds, the bankers are going crazy, and the lawyers are wondering what's going to happen, the Navajo Supreme Court rendered a decision. It was almost like it's kind of Bush v. Gore. And it said, of course, traditional law is the ultimate law of the Navajo people. But we rule as a judiciary that when the people have spoken in written form and put it down as a statute, that is now become the traditional law. That has that status because the people have spoken. And that rule of law not just allowed the bond deal to go through, it had that nation-building confidence in the eyes of capitalism that, okay, Navajo has a working government, whether it is a traditional format, a Western-style format, but it can make decisions. And once the decision was made, President Shirley said, okay, walked away just like Al Gore did because the court had ruled. So that's the way courts influence the economic development of nations, is by having intelligible dispute resolution processes so people know one way or another things will be resolved. That's a story for your article. That was a good one, yeah.
So building upon that a little bit, I think they're both, you've given great examples of contemporary tribal legal systems. In your work, do you see that the jurisdiction is expanding, or do you see it contracting? And in which jurisdiction? Are there any type of patterns that you see?
Yeah, so here's what I'll say about that. Short answer is tribal jurisdiction is expanding pretty dramatically all the time, but it's weird to think about why that is. First of all, the notion of sovereignty, I told you where it comes from. It's the Leviathan. So tribes didn't really go to Congress or to court until like the 60s and 70s and say the S word, as Steve points out. They didn't even know what that was. It's totally foreign, to Indian communities. To say we're immune from suit is pretty weird because, first of all, we didn't have lawsuits to begin with, and secondly, What the hell is a sovereign? I mean, they have, like, the world is our sovereign. Anishinaabe Key is our sovereign, right? Not some dude who got the most votes in the last election. So the whole thing is a little bit weird, but tribes have been playing this game now pretty successfully for a half century, and it is a game. It's an American game. It's a Western political game, and we're playing it probably better than just about anybody around in the United States. A lot of the tribes are. Not all the tribes. Some tribes really struggle, but there are tribes out there that are running circles around state governments. Mostly those tribes are in Oklahoma, Michigan, some in California, Washington State. It's amazing to watch them outgovern those states and local governments, and especially the federal. It's really easy to outgovern the federal government because one thing that the federal government is not really good at doing is actually governing. The United States does amazing things, but ask anybody who works in the Indian Health Service or Bureau of Indian Affairs if they think they're the right person for the job, and almost all of them will say, no, the tribe should be doing this, not me. And then they should hire that person. The tribe should hire that person to do it. So let's talk about what that means, outgoverning somebody. Sovereignty, the tribes are changing the whole philosophy of sovereignty, but very subtly, underneath the noses of those who love sovereignty. Mostly when you talk about sovereignty in the United States, you're talking about at the Supreme Court, where the Supreme Court says, and Steve actually had a great story about this, the Supreme Court says, when we rule on something, we're the sovereign. We decide what the Constitution means, and everybody's got to take our word for it. And they do. We totally do. So same with Congress. When Congress passes a law, Congress says we're exercising congressional power, we're the sovereign. And when the president and the executive branch make a decision and take action to enforce the law that Congress passed, they're the sovereign. Same with states and local governments. They're the sovereign. But they don't actually promise to do good work when they exercise this sovereignty. Usually I will tell you this, somebody should do an empirical research on this. When somebody who's in a position of power in state, federal government, and tribal government, I hate to say it, says we're doing this because we're exercising our sovereignty, almost every single time they're doing it to fuck somebody over. Now, if you go into tribal communities, what you're seeing is we're exercising tribal sovereignty. So there's this aspect, we have a top-down government. We've got people in positions of power who are exercising sovereignty. But you know what? Tribes are earning sovereignty because we can't go to the Supreme Court and say, well, we're sovereign. We're more sovereign than Oklahoma is, or Michigan. And the Supreme Court's just going to laugh and say, you're so cute, get the fuck out of our court. And that's what they've been doing for every single day since the 1789 when the Supreme Court was created. So tribes are earning it. They're not asking for it. They're doing a better job. So when you see a case like McGirt versus Oklahoma, where you see tribes that are arguing against the state of Oklahoma saying, well, I love the amicus briefs where the tribe says, there used to be all these hospitals, rural hospitals in Oklahoma within the Indian country of the reservations that were at issue in that case, the one reservation, the Creek Reservation. And Oklahoma, their government and their economy is so bad and so tanking that they can't keep those rural hospitals open. So you know what? We bought the hospitals, the Creek Nation did, and Muskogee Creek Nation, and they operate those hospitals now as tribal hospitals, privately owned tribal hospitals. That's outgoverning your sovereignty competitor. And that's where tribes are actually earning more sovereignty. Tribes are also earning sovereignty, weirdly enough, in Congress. So when Stephen said, if you punch a cop now and you're non-Indian, you can't be prosecuted by the tribe. Well, as of last year, some tribes can actually prosecute those non-Indians. As of the last decade or so, a limited number of tribes who meet certain criteria and can prosecute non-Indians for a limited number of crimes like domestic violence or intimate partner violence or punching a police officer. Got to protect those cops. Other things too. It's a small list, but it's growing. And the reason it's growing, Congress has twice now created a list and added a list of crimes that tribes can prosecute non-Indians for, is because tribes are doing an amazing job at it. The ones that actually can do an amazing job at it, which is about 36 tribes out of 574. But it's sort of like a pilot project. Can tribes actually do a better job of governing? And the reality is they absolutely can, and often do, especially in states like Oklahoma, Idaho, states where the state government effectively is a failed nation. They are not governing in a meaningful way in some of these states. And tribes are stepping in where they have the territory, where Indian country is. Tribes are stepping in the shoes of other states. We've been doing this in Michigan forever on Clean Water and Clean Air Act stuff. The state of Michigan is essentially quietly devolved its power to the tribal communities in northern Michigan because we're better at observing the environment and calculating where the pollution sources are than the state of Michigan ever was. Little things like that, that's where tribes are really undermining what sovereignty means. They're earning it as opposed to just assuming that they have it on paper.
And they're exercising. Sovereignty is a muscle. You have to exercise it. And I mean the pun by that. One aspect is going to Congress, and we don't want to take any fire away from the next panel, which will talk about the Violence Against Women Act. But why is Congress paying attention? Well, because money. Indian nations now have money to hire all the lobbyists that the oil companies and everybody else does, so they have a presence in Congress, and Congress listens to them. Is that a good reason? Perhaps not. It's the American reason, and tribes are being heard. The other thing, or two other things that tribes are doing, is working within the system we have. I said before that tribes have almost no civil jurisdiction absent consent of non-Indians. Well, create consent. You walk around this city, and at the corner of every big office building, there's a little sign on the sidewalk that says, this is the property line, and you crossed it. I remember up at Harvard every year, they would close the gates for one day a year just to prove it was all private property and couldn't be adverse possessed. So you create consent. Everybody who walks into your cigarette store, your casino, who steps onto your land, big sign. You're now subject to the jurisdiction of the Ho-Chunk Nation, the Grand Traverse Band, the Oneida Nation. Every contract, we made this when I was at the General Council of the Oneida Nation. Even if we were just buying linens for the casino, every contract had a little sovereignty rider that they consented to our court jurisdiction. The other thing to do is work local, especially up in the upper Midwest. Working with local tribe, with local court systems, local state court systems, county court systems, working through ICWA and child care issues, family court issues, domestic violence, substance abuse issues, creating systems, working with their neighbors expands jurisdiction because the state courts are overburdened. They're happy to have help, and nobody's really a bad person. I mean, there are plenty of bad people, but if a Native Nation approaches a local county judge and says, we want to talk about the drug problem in the area, not on the reservation, because there's no boundaries, those things work. There's all sorts of protocols, statutes in a lot of states. Some states have their own ICWA laws to address this. So all of these things are expanding the jurisdiction. It's not just the court jurisdiction, it's the overall jurisdiction of Native nations, and it's only increasing.
Let's talk a little bit about emerging issues in tribal jurisprudence. What legal issues do you see becoming increasingly important in tribal contexts? Are there intertribal trends you've seen, and who are the drivers, or what is the driving force behind these emerging issues?
Let me go again? Or?
Sure.
So there's just so much to say on this question, but I think I'll focus on a couple of things. One is, really one thing, civil rights. So if you are somebody at work and here in the city and you have a sexual harassment claim against your boss, there's a structure in place to hopefully for you to be able to go through state or federal court or the Equal Employment Opportunity Commission or the state of New York's version of whatever that is to try to get some sort of relief. And the reality is you're going to lose. You're not going to win hardly anything in state or federal processes if you have had your civil rights violated in some respect, either by a private entity or even by the government, especially the government. So you're not going to win these cases. And the reason for that, in large part, is that Congress is run by the rich and wealthy. And the last thing I want to do is make it easy for them to get sued. The same way that the Congress limits its ability, the United States' ability to get sued, and they don't really waive federal sovereign immunity all that much. They do it, absolutely, and they have all sorts of waivers in place, but they are so strictly construed by the federal judiciary as to many times be meaningless. And so when I start thinking about the different political philosophies of tribes in the United States, I urge you to start looking at the Fifth Amendment just as an example. Read the Fifth Amendment sometime. It's one big, long, giant sentence. It's a total word salad. And out of the Fifth Amendment, we have so many things that we talk about in constitutional law, and it's baffling to me that it's all one sentence. Things like due process. The word due process appears in the Fifth Amendment. That's why we have due process. The word takings and just compensation appears in the Fifth Amendment. Because if the government takes your stuff, you have a vested property interest, they have to compensate you for that. They also have to provide you due process. There's also a habeas right in the Fifth Amendment. There's a right against self-incrimination in the Fifth Amendment. There's all sorts of stuff in the Fifth Amendment that, and when I teach my summer program class for the Pre-Law Summer Institute in Albuquerque once in a while, I tell them federal Indian law is Fifth Amendment. It's the Fifth Amendment class. Almost all the cases come from the Fifth Amendment. The notion that race discrimination or gender and sex discrimination is illegal as opposed to the federal government isn't because of the Equal Protection Clause of the 14th Amendment. It's because of the Fifth Amendment. Because there is no Equal Protection Clause that specifically applies to the federal government. It only applies to the states. So the Supreme Court has said there is one. It's invisible. And it's in the words of the Due Process Clause of the Fifth Amendment. And all that's fine. But you know what the Fifth Amendment really is? If you read it, who would write such a ridiculous word salad? James Madison. And why did he write a ridiculous word salad? Because the Fifth Amendment is about protecting rich people from the government, from taking their shit and putting them in jail for crimes. That's fundamentally, read the Fifth Amendment with an eye towards understanding what it really is about. It's not about protecting the little guy. There's nothing in there about equal protection. There is due process for people who can afford due process, and that's the rich, wealthy elite. This is 1791 we're talking about. The only people who are protected by the Fifth Amendment in 1791 are rich, white guys. Mostly, they're slave owners or slavery enablers, and all of them are Indian killers. Set that part aside. So, that's what the Fifth Amendment is really about. We love to say that it provides like basic protections for everybody in the United States against the government, but it doesn't really do that. But you know what? We have all this stuff in the Fifth Amendment, and our own tribes have them in our constitutions. We tend to also comply with the Indian Civil Rights Act, which is a federal law that in 1968, this is what Congress thought the Constitution said. It doesn't say a lot of the stuff in there, but that's kind of like the 1968 snapshot of what Congress thought the Constitution should be. So tribes tend to follow due process and equal protection. And you know what? We don't have to follow state and federal court precedents. They're so crabbed in how they interpret those provisions. You know what due process means in federal and state courts or in the agencies? It means the bare minimum that the government has to do before they take something from you. No more than the bare minimum. That's not what due process has to mean. And tribes are actually starting to begin the process of trying to figure out what due process should mean for tribal communities. And it could be a lot more extensive procedural protections. And as a matter of reality, I'm talking about the tribal communities I've worked for, the procedural protections we give to individual tribal members vastly is beyond what you will get in state and federal communities. Absolutely. Not every time. And what the emerging trend is, I think, is that and you're already seeing this. 20 years ago, when I was first becoming a law professor, what was in the news all the time 20 years ago was, in California, 40,000 Indians have been disenrolled from their tribes. Now, that was a made-up number. It is thousands of people, but I don't think it was ever 40,000. I don't even know if there's 40,000 tribal members in California. But, and the same was going on in Michigan with Saginaw Chippewa Indian tribe. They disenrolled people who were dead. So then they could summarily disenroll all their descendants and didn't give them a day in court. That was later reversed because they have a judiciary that consists of people like Frank Pomersheim, who was a law professor at South Dakota, and Mike Petoskey, who's a tribal member and tribal judge in Michigan, and Kerry Vicente, who was a professor and Hickory Apache member from New Mexico and Colorado. And they held the tribe to the flame of justice. I just kind of made that line up. But they just said, you can't summarily just deny people these rights. And Saginaw Chippewa spent the next 15 years aggressively moving towards disenrollment, and they succeeded. But the amount of process, ultimately, that the people who were disenrolled got was considerable, way more than they ever would have got on a similar kind of situation in state or federal court. And I think that's where we have emerging issues of intractable political disputes where tribes, because they are exercising sovereignty, are committing, some tribes are committing horrible human rights violations. But tribal communities elsewhere, you're not going to be able to go to state and federal courts for guidance or leadership on human rights. You're going to go to other tribal communities in human rights. And I go out of my way when I get a membership case to talk about the obligations that tribal government has to its own citizens. We're all relatives in really important matters. I mean, biologically, to be sure, we're often relatives, but we're also part of the same universe, Anishinaabe. We have obligations to each other. And in our language, Anishinaabe, Moin, we call it Minoba Madzawin or Inawin Dewin. We all have obligations to each other. And to summarily strip each other of rights or privileges or our citizenship or our identity is complete garbage. And that's the kind of thing the colonizer does. And so when you have tribes doing the right thing in some contexts, it really dampens what tribes are doing. It really contributes to them not doing, other tribes that are doing bad things to doing bad things. So we don't talk about, we don't hear as much stuff in the news as we did 20 years ago about mass disenrollments. Many of the tribes in California that did engage that went back on that. And many tribes have adopted rules, and Michigan is true, does this as well, prohibiting the disenrollment of people, even if they've been, accidentally or incorrectly enrolled within the tribe. Once they're in, full stop.
So I'll stop right there. The other thing driving the change or the emergence of tribal jurisprudence and jurisdiction is that rule of 5. Just like we think back in the civil rights context to the Warren Court, we think back roughly to the same court, and even a little later, there were good decisions. There was the Oneida Land Claims. There was Holyfield upholding ICWA. Nowadays, the Supreme Court is at best very parsimonious, and you keep the statistics. We've all thought for a quarter century now at least, maybe more, it's malpractice to take an Indian law case to the Supreme Court. And so tribes have to do it for themselves.
I would say this, that the statistics that we sort of follow, when I started writing in Indian law, David Getchus had pointed out that for about a 20-year period, the 80s and 2000s, tribes were losing at the Supreme Court at a rate worse than convicted criminals were. And I think that's probably still the case. But since 2014, tribes have actually won something like 10 out of 14 cases. And I want to highlight something that's really important. That has never, ever happened before. You will actually hear people say to you at some point, usually old white guys, hey, back in the 60s and 70s when tribes were winning all of their cases, they were not. Tribes won some big cases in the 60s and 70s, but they still lost about 75% of the time. And that's been true throughout the entire history of the U.S. But from 2014 until now, tribes have won absolutely unprecedented 10 out of about 14 cases. That's all going to end this year, by the way. And we're going to go into a deep, dark spiral of horror, but that's where we've always been anyway. So that's fine.
The only thing that I would add to emerging issues, and it's because Professor Fletcher hit upon some of the issues with disenrollment, but an emerging issue as well is blood quantum. And I think that we're seeing that more and more just because it's something that, colonial practices incorporated blood quantum into our documents like our constitutions, and we were required to have constitutions. And now we're getting to a point where if you don't have a tribal member spouse or tribal member children, you start to have tribal member descendants. And then how do tribal member descendants fit into things? So Ho-Chunk, we're a patrilineal society. As I introduced myself earlier, Hunchi Kikarach. My clan is Bear. And the reason why I'm Bear Clan is because my dad was Bear Clan, his dad was Bear Clan, and it goes all the way back. But now I have children and they're enrolled Oneida, but they're still descendants, but some of the tribe's laws are starting to apply to them. And it's almost like creating second-class citizens, because it's oh, we want you to continue the tribe's custom and traditions and learn our language, but oh, by the way, we're not going to give you per capita. Oh, by the way, we're not going to let you be leaseholders, but we will let you do certain things. And so I see that as an emerging issue as it sort of becomes fractured. Last topic, engaging in this work. So now let's talk for folks listening, particularly students who may be interested in engaging this work in their studies or career and how they chart their path. What resources should we engage with so that they can learn more? Any ideas as to how to engage in this work?
Read Turtle Talk every day.
You want to go first?
Well, the advice I always give to law students generally, but especially those who want ultimate careers in Native American law, and you've already accomplished this in part by going here, is get your ticket punched. Go work at a big non-Indian law firm. Learn how to do the law, because you're going to be involved in it even if you're fighting it. For example, the Southern District of New York, all you want to do is fight crime. They don't hire out of law school. Go to a big firm, learn how it works, learn all the tools in the drawer, so then when you work with less for the government, the federal government in the Southern District, or DNA Legal Services, you know all the things you can do, you know what's effective, you know what's not, you know how to take a deposition, who not to depose. Learn as much as you can, and then bring that knowledge to wherever you want to go next. Matt?
Yeah, that's really interesting. I usually tell students not to go work for big law and try to run from screaming from it as much as they can. But there is a lot of that you can absolutely learn in a situation with a job like that. But I totally agree with Steve about the other part, which is if you want to do this work, do the work. Go work for a tribal community. There's lots of places in Indian country where you can get a job. You can work, as I did, as a tribal attorney. You can work as a tribal judge. You can work as a clerk to a tribal judge. You can be a prosecutor, a defender. Many reservations are home to legal services organizations. There's all sorts of work that you can do within a tribal community. I urge you to work for a client that is tribal. I urge you to work around Indian people, and there's just no other kind of experience like it. It's hard work, but I can't imagine myself personally working for a big law surrounded by non-Indians. I got Chimukman phobia once in a while, and it doesn't work out for me. And I didn't work it for my own tribe until many years after I was practicing. I went elsewhere. And made all of my mistakes there. Not all of them. I still make mistakes every day. But it was great. And I felt like, in some respects, like I was an Indian person working for other tribes that I knew nothing about. I almost felt like an anthropologist. And trying to be an ethical anthropologist where you're learning about your client all the time, every day. And you're immersed in it. And you learn about their culture. You learn about the language. You learn about the history. And it makes it viable for you to do that work, but it really also shows you all of the different legal possibilities to these questions. And it's just a rich source of law review articles. That's really how I got started. I said before facetiously that my wife's friends were all dumbasses. They are not. They're freaking geniuses. But they didn't work for tribal communities. Some of them came from tribal communities, but they didn't work. They didn't know what the legal issues were, and they were focusing on other issues. And I thought, this is a niche that I could really work on. So my first articles as a scholar were questions that my clients asked me. Like 2 or 3 of the 4 tribal clients I had, the different tribes I worked for, asked me this horrible question: how do we drug test all of our employers? Is that legal? All of our employees. And I said, that's a horrible thing to do to somebody, but let's talk about the law. And so I learned everything I could about government drug testing of employees. And for the most part, doing all this research, there weren't any tribal court cases. There were no state or federal court cases about tribes doing random drug testing of their employees. But I also was able to ask around in my different rounds through the tribal government building. The tribes thinking about doing random drug testing. What does that mean to you culturally? And I got some of the most amazing answers that were so legally salient that I thought they were absolute trump cards as to why the tribe shouldn't do this. For example, at my own tribe, I asked my legal assistant, her name is Mary. I said, Mary, what would happen if we did random drug testing? She said, well, I wouldn't do it. And I'm like, I know, you're going to get fired, but none of us want to do it. But what does it mean culturally? And she said, well, the policy that they're kicking around starts with taking a hair sample. It's like, we're Native people. Our memories are contained in our hair. There's no way that I'm going to let you take my memories from me. And I'm like, okay, so there are alternates. If you don't want your hair taken, what would be next? Well, a urinalysis analysis. They're going to take a piss test. She says, I wouldn't do that either because I'm a woman. And especially on moon time, there's no way that a woman in that particular time of power and vulnerability is going to be engaged in delivering a sample of her body to a government entity. And as a facetious thing, she said, by the way, when they do drug testing, I'm on my moon time every single day until I stop working here. But these were arguments that don't show up in federal and state court cases. They didn't show up even in the analysis or the reasoning of my client, who were tribal people. And I ended up finding out why the tribal council, every tribal council, wants to randomly drug test its employees. Because the good ones are going to run for council someday. And this is a way to fuck them over before they ever become political competition. Almost every single council member told me that's why they wanted to do it. It was the worst thing I think I ever heard. But it was delightful, because then I could say, well, at least you're being honest, and this is a reason why we're not going to end up doing it. And none of them ever did.
In terms of fighting for tribes, there is a benefit to it being federal common law. It's just a more open field. There's more room for argument. There's, of course, an incredible 200 years worth of history, but it's full of open phrases. Like, when you teach Indian law, you spend 14 weeks trying to define what is a domestic dependent nation. And the answer is, well, this case said that, and that case said this, and this is positive and that's negative. But there's no holistic sense of it. The Supreme Court didn't describe it. So you can work to change that meaning or fill it in or apply it to this or that situation. So there's more, the law is more plastic, sometimes in a bad way. It can be bent too far the wrong way, but it can also be bent positively. And it's really when you walk out of law school, the only thing you're really competent to do is argue in front of the Supreme Court. Well, that's great, because that's where Indian law happens. We don't know the answer until it comes down and somebody got 5 votes on one side or the other. So it's perfect for law students to get involved in the big issues right away, because it is all federal common law.
The only addition that I would add in terms of engaging this work, where I started in my summer was clerking for tribal court, which then led to a job. And after 1 year of clerking, the tribe's judge, who was a non-member, non-Indian, was not going to be reelected. And so the chief judge at the time looked to me and was like, well, hey, you were a summer clerk and then you were a law clerk for a year. Why don't you put your name in? And I was like, because I'm a year out of law school. That's why I'm not going to put my name in. And he was like, no. You're doing all the work, because the non-member, non-Indian has sort of checked out. And so I was writing all of his decisions. And I was like, all right, yeah, it'll be nuts, though, because they won't put me up there because I'm a year out of law school. And I became the youngest tribal court judge, JD trained, in the country. And it was 1200, which meant my whole tribe had believed that I could accomplish this. And that was what sort of led to me working for a tribal community. So if you're hoping to engage in tribal legal services, I think first things first, find a clerkship or some way in which you can contribute. And oftentimes your law schools will in fact pay you to do what they consider nonprofit type work. And working for a judiciary or a government office might fit that bill. And then additionally, if you're interested in this, I get to give my plug for the NYU Yale American Indian Sovereignty Project, where you'll get some experience right away about what's happening on a federal level or seeing what's happening in the circuit court level or coding tribal constitutions. All of these are ways to become engaged in this work. So our next step is to see if, in fact, there are any audience questions for our panelists.
One more thing on that, though. It's a small world. It's a small bar. And there are a few conferences coming up next month. There's the Federal Indian Bar Association. You should reach out. Everybody is going to want to help you wherever you go. And there are places like the Indian Law Section of the Federal Bar. There are regular conferences where everybody comes to meet. I remember years ago, I was a young law professor at St. John's, and I met a young guy who was just a 1L at Yale. And it turned out to be Kevin Washburn, who ended up heading the BIA. It's the people, some of the folks in this room are going to go on to great things in their nations or helping through, if they decide to work in the federal government or in private practice. But it's a very strong, and I say this as a non-Indian, it's a very strong network, it's a very open network. All the law professors everywhere are going to want to talk to you and help you. All the folks who are involved in clinics, like here at Yale or in Oklahoma or in Arizona. So take advantage of that. It is a much more connected world than is visible, because you would think it's just, well, it's small, but it's not.
Any questions? Yes.
This is for Professor Fletcher. What happens when we, if possibly, are falling into that deep darkness by or talking after that? So I find myself, at least when I was a student, first learning Indian law, was angry, rageful. And then as I teach it, I try to be a lot more mindful, trying to instill some optimism in my students. I still find myself just like, how do we go from here when the federal government, states keep moving that goalpost? And then we have Rakhine, and then is that this?
There's an easy answer to that. And the answer really fundamentally is that the justices on the United States Supreme Court are not really very good at being a lawyer. They're really not. They don't understand anything to do with Indian law. They don't understand the consequences. And so think about a case like Seminole Tribe versus Florida. This is a case in the 90s where the Supreme Court totally rewrote state sovereign immunity law, and they used an Indian law case to do it because they thought, well, nobody's going to let an Indian tribe sue the state of Florida. That's ridiculous. So we can rewrite all of this law to benefit states going forward. And it gutted the enforcement mechanism of the Indian Gaming Regulatory Act. And so for 2 years, there were no gaming compacts between tribes and states. But then tribal attorneys came up with a way to get around Seminole. And now we don't even talk about Seminole anymore. Same thing with cases like Nevada versus Hicks, right? Nevada versus Hicks is a Supreme Court case. If you just read it in a vacuum, it looks like Justice Scalia is saying, all right, we've had an experiment for 20 years with letting tribes in a limited fashion exercise jurisdiction over non-Indians. Well, that's all over as of today. He was wrong because of the things that Stephen said. Thousands and thousands, hundreds of thousands of non-Indians, non-members have consented to tribal jurisdiction. If they want to work for us, they consent. If they want to live on the reservation, they consent. If they want to do anything with Indian tribes, and a lot of them do, because we got stuff, they consent. So Nevada v. Hicks is nothing unless you're a state police officer. They can do whatever they want. They're immune from anything. But the case doesn't mean anything anymore. So let's say the Supreme Court, the one possible exception to that is the Brackeen case. And it depends on what the Supreme Court chooses to do. The worst case scenarios in Brackeen are so bad that all of Indian law goes away. What the state of Texas is saying is that Congress can't pass laws in Indian affairs. Full stop. Just can't do it anymore. And, the Constitution kind of says you can, but if you have 5 votes, you can do anything you want. They got 5 votes for that, if they wanted to. I don't know that they want to. So that's one. And then what if they say, the second one is the equal protection part. This is the part of the Fifth Amendment that doesn't say equal protection, but the Supreme Court reads equal protection into it. By the way, you want to know when they did that? In 1944. So they could legalize Japanese internment. That's where that provision comes from. The equal protection component of the Fifth Amendment comes from the Korematsu case. I'm not making this up. Okay, so if they say that Congress passes a law and creates a classification that says this statute applies to Indians or benefits or is detrimental to Indians, quote Indians, and doesn't say who Indians are, the Supreme Court is likely to rule that that's unconstitutional because it creates what they call a racial classification as opposed to a political classification. Although I don't know that they're going to say that because they don't understand that there's a distinction. They'll say something else. But the point is, if they do that, that is also devastating. A lot of statutes that Congress passes apply to Indians. In fact, all of Indian country criminal jurisdiction is about Indians without a definition for who Indians are. So right now, a federal prosecutor can prosecute somebody who's not a tribal member but is Indian, so long as they can prove to a jury beyond a reasonable doubt that person is Indian. And the stuff that they do in those cases is kind of hilarious. They count how many times they went to powwows and shit like that. So that's all ridiculous, but that's actually the law. It's the law. The Indian Civil Rights Act says tribes have jurisdiction over, quote, Indians. in criminal jurisdiction. So who's an Indian? Well, anybody that the prosecutor can prove is an Indian. Stephen, you've been in Indian country long enough. I bet you if a prosecutor can indict a ham sandwich, they can prove to a jury of non-Indians that you're an Indian too. I guarantee that could be the case. It'll get reversed on appeal, but at trial you're going down. All that is to say is the court doesn't really know what they're doing in this stuff, and so you let them have their day, like, oh shit, we lost, so what? You know the Castro Huerta case after McGirt that came out last year? It looked like it was a huge retrenchment after McGirt, but all it did was it helped Oklahoma. Oklahoma wanted some of its powers back. And the way the court wrote Castro Huerta was to say that any state, if it wants to, can exercise criminal jurisdiction over non-Indians who commit crimes against Indians. We used to think that unless Congress said it was okay for states to do that, then states couldn't do that. And the Supreme Court said, we don't have to think that way anymore. States can do it. Guess how many states outside of Oklahoma have decided to go all in at the invitation of the Supreme Court? My guess is that it's 0. Why would they? Why would states want to prosecute non-Indians when the federal government's going to prosecute non-Indians, or the tribe, even in limited circumstances, is going to prosecute non-Indians? So most states don't have a budget for that sort of thing.
Well, and even more darkly, they'd be protecting Indian victims, and they don't care.
I won't disagree with that either. But that's part of it. You got to have a good sense of humor. Remember, they're not very good at this stuff. I mean, they're really old. You know, a couple of years ago, they were starting to issue cases on the searches by police officers of cell phones. And the opinions coming out of the court were gibberish because most of them did not own a damn cell phone. They didn't know what it was. I think their clerks probably had to explain to them what a damn cell phone was. There's a rumor that RBG never once had an email address, had no idea how to do email. I mean, that's who they are. I mean, I'm totally ripping into them, but they're judges, and they only know a certain part of the world, and they botch things up left and right. But when you botch it up so badly, you can kind of just like, let's just ignore that. And we totally do. It's awesome.
It raises another aspect about the Supreme Court's practice, because whatever the case is before the Supreme Court, it's never about Indians. It's always about either federalism or separation of powers. You know, what's the backdrop? Does the state get this power? Does the federal government get this power? Is this an executive branch deal? Can the president say this? Or did it have to go to Congress? Always look for the big wheels turning behind. I think Rich Monette said, Indians are federalism's football. The Hughes case, going right back to Worcester v. Georgia, about the one that said state laws have no power. That's John Marshall arguing with Thomas Jefferson about federalism. They were actually cousins, but Marshall was a federalist and wanted federal power, and Jefferson and later Jackson would have gone the other way. So always look for the big wheels anytime you see a lone Indian child or attacks on a mobile home or something that makes its way to the Supreme Court. About Indians, because it probably has nothing to do with Indian law. That's right.
I think just adding upon like the positives is that I feel like we have a generation that's getting good at things like podcasts. You know, this is Our Land with the Brackeen, and it just brought up so much that it was like, you know, I felt like, what it would be like #winning, because I was like, finally someone somewhere is like putting all of this out there and like taking a page from Steve's book. This is capitalism. Like, you know, I'm like, come on, like this is all about money. And we can look at this podcast in Brackeen, and it's run by someone who's a tribal member in Oklahoma, and this is a big deal. And so I think we're getting a little bit more savvy, I think, as we're going along. At least I hope. There's like a couple steps forward, a few steps backwards.
That I want to highlight that too. And some of the work that when I started practice, you know, if you would, the Supreme Court would, the universe that they are adjudicating a case in is exclusively the universe of the briefs that they're before them and the amicus briefs. And what I started to learn as I was reading some of these briefs and how the court would take an amicus brief before oral argument, and you would hear a justice ask a question based on something they read in an amicus brief. And what we did in Indian country, I think, were very late to understand, is that the other side can lie to the Supreme Court about facts on the law. And there's no internet in the 90s or any time before that to question that. Johnson v. McIntosh was totally based on a lie. It was a collusive case. Both parties, both attorneys were paid for by the same party. You can't make this stuff up. And that's still true to this day. But the thing about, now we know that you can lie to the Supreme Court, or you can call people out when they are lying to you. So we know how to muddy the water for these factual allegations made by the other side. And so the court doesn't know who to believe anymore, and that's actually good for us. But more importantly, what you're pointing out is absolutely right. Because of the internet, because of people who are savvy, we can actually articulate facts on our own side that are much more useful. So now you're starting to see briefs, and I think I mentioned this before with Creek Nation. The tribes are bringing out facts about how well they're governing, about what the reality is about what will happen in Oklahoma if you declare that the Creek Reservation is Indian country, how many cases are going to be dismissed, that sort of thing. The tribe actually knew that information, and it was a minimal amount of concern. And so when Rebecca Nagel, who's the podcaster from This Land, writes an op-ed, and I really don't know how accurate her empirical work is, because some of it's kind of questionable, but it's kind of smart how she does it. She publishes it like 2 days before oral argument, and Justice Sotomayor's clerks will probably feed her a question that is asked during oral argument that comes directly from Rebecca Nagel's article. It's kind of awesome. Whether the article is super like scientifically peer review accuracy isn't really relevant, but the question that comes from the court frames the way the parties have to respond. It frames the court's thinking on a case. And framing of a case is really, really important. It used to be you didn't have to frame an Indian law case. You can just point to them and say, they're Indians. And so don't worry about what they're concerned about, because they're irrelevant. We're going to do our thing with our federalism football, which is an awesome metaphor, by the way.
The other thing is, even if your career doesn't start out principally in Indian law, you can write briefs. You can write them with the Sovereignty Project. You can help out the Native American Rights Fund. Now, amicus briefing has gone off the charts. You've got, the associative, I remember it was Patchak, or the one before it, the Narragansett case. The American Association of Lexicographers, the people who make dictionaries, wrote a brief, because the question in the case was, what is the meaning of the word now?
That's right.
So there's opportunity, even if you're working at big law wherever, you could always help out writing a brief. Or part of a brief, or researching, or whatever's needed.
There's a little secret to Indian law about me, about amicus briefs. If I sign on to an amicus brief, or actually am the primary author of the amicus brief, it means that tribe is going to lose. Because what the tribe has done is gone to look for like the legitimate brief writers, people like Amanda. And they're like, well, this isn't a loser case, and I've got lunch later, so. And they go like, well, is Fletcher available? And I'm just like, yeah, I'll sign anything put in front of me. So yeah. That's the secret to Fletcher in Indian law.
I'd like to thank our panelists today. I'm sure they'll be around if you have any individual questions, but thank you very much for your time today.
Yep. If you want a comic book. Thank you, Amanda. It was delightful.
Thank you.
Hi, everyone. Welcome back. Thank you so much for joining us today for this exciting panel discussion. My name is Olivia. I'm a 2L here at NYU and a member of the NALSA board. And it's my great pleasure to introduce our guests who have joined us from across the country to discuss tribal responses to the missing and murdered Indigenous women crisis. First, we welcome our moderator, Precious Benally. Professor Benally is a citizen of the Dene Nation in northern New Mexico and is the founder and owner of P. Benally Consulting, providing training, assistance, and knowledge sharing to tribal nations interested in developing and enhancing their justice system responses to substance use, child welfare, incarceration, and reentry issues. She also teaches Native American law at Columbia Law School and Rutgers Law School. Professor Benally obtained her law degree from Columbia Law School, where she focused on international indigenous law and policy, peacemaking, and other forms of alternative dispute resolution. Professor Benally graduated in 2008 with a bachelor's degree in philosophy and Native American studies from Dartmouth College. Our first panelist is Angel Charlie. Angel comes from the Coeca one of the 19 pueblos of New Mexico. She comes from generations of powerful women who hold the sacred ability to heal our families through love, action, and connection. Most importantly, she is a mother who is learning how to support a generation of young leaders like her child. As executive director of the Coalition to Stop Violence Against Native Women, Angel remains focused on leading values-driven change that centers the needs of coalition members, the voices of tribal communities, and the people impacted by systemic oppression. She's passionate about disrupting cycles of violence, building community power, and transformative community-based solutions in the movement to end gender-based violence. Angel holds a degree in communications from the University of Hawaii. She also serves as the vice chair of the Native American Professional Parent Resources, is on the board for the Albuquerque's Sexual Assault Nurses Examiners Collaborative, and serves as a voting member to the Alliance of Tribal Coalitions to End Violence. Our next panelist, sorry, I'm going a little out of order here, but is Carmen O'Leary. Carmen is the director of Native Women's Society of the Great Plains. She is a citizen and resident of the Cheyenne River Sioux Tribe, where she has gathered her experience and expertise to develop programs that serve Native women experiencing violence over the last 40 years. Carmen is a trainer on advocacy around sexual assault and domestic violence. She is a certified trainer with the Federal Law Enforcement Training Center for Law Enforcement on Domestic Violence. Carmen has worked at providing insight on tribal codes in relation to sexual assault, domestic violence, and the issuance of protective orders. Working for state, tribal, and national boards has given her a wide range of insights and experiences around the issues of violence in Indian country. And our final panelist is Jocelyn Getchen-Kestenbaum, an associate professor of clinical law at Cardozo School of Law, where she directs the Benjamin B. Ferencz Human Rights and Atrocities Prevention Clinic and the Cardozo Law Institute in Holocaust and Human Rights. She's also a member of the Nichasok, a working group that focuses on prevention and accountability for survivors and families of missing and murdered Indigenous persons in Lenapehoking. Professor Kestenbaum's scholarship and advocacy focuses on human rights, public health, and atrocity prevention, especially related to preventing and responding to sexual and gender-based crimes, slavery and the slave trade, Indigenous rights, and human rights violations against minority groups. She holds a JD from Cornell Law School and an MPH from the Johns Hopkins University Bloomberg School of Public Health. We are privileged to have you all here, so let's please give them a warm welcome, and I'll turn it over to Professor Benally.
Thank you. Yat a precious Benally inishia, but initially touchini bashishin, Bilagana dashiche, Sinsikani dashanelle. Hello, welcome. My name is Precious Benally. I am the Folded Arms clan, born for the Red Running into the Water clan. My paternal grandfather is a Klumptree clan, and my maternal grandfather is German. So welcome. As Olivia said, I'm originally from the Four Corners area of New Mexico, a citizen of the Diné Nation, and I am joined here by three wonderful advocates, educators, in addressing the missing, murdered, and Indigenous peoples crisis. So before we start, kind of want to have each of them introduce themselves, their work, what brings them to this work, just to lay that ground. So Carmen, would you like to start?
I guess we get to share, Angel. Carmen O'Leary. I am a Lakota from Cheyenne River. There's 7 bands of Lakota, and everybody always hears about Oglalas. That's one band, and there's 4 bands at Cheyenne River, and that's on my mother's side. On my father's side, I'm a 3rd-generation boat person because he came right out of Ireland. So I acknowledge all of the people in my background. I think it's kind of important. I always talk about, in my background, I am like the results of all of the federal Indian law that came down through the ages, you know, whether it's the Dawes Act, that's how the Irish got over to South Dakota, and the Louisiana Purchase. I got a few of those fur trappers in my background. but I have lived my whole life at Cheyenne River. My grandparents were Lakota speakers. They did not pass that down because of what they went through. And I came to this work, because of the whole abuse that I've saw all my life against Native women. One of my earliest memories was going to a hayfield where my dad and the hired man, I was still small enough to stand up on the pickup seat in between them. And they had drove by this one stucco house because a couple nights before, a man had ran into his wife there and killed her against that. So it's like there was story after story, and even seeing it. So not being able to do anything about that is impactful. Yeah.
Hi, everyone. Goatsi Hopa. My name is Angel Charlie, and I serve as the executive director of the Coalition to Stop Violence Against Native Women. But the other roles that are important to me and that I belong to are I am a mother, I'm an auntie, my niece is here in the room with me, and I just want to acknowledge for a minute that it's her dream to go to school at NYU and practice law. And so we're speaking that into existence today, and thank you for, yeah. Thank you all, everyone in the room, for being an example for my niece. So the Coalition to Stop Violence Against Native Women, we're one of, is it 19 now, Carmen? I think so. Yeah, 19 tribal coalitions. We're set up regionally across the United States to address this issue, and we do it all each a little bit differently. But we're based out of Albuquerque and serve the Southwest region. So there's 19 Pueblos, Navajo Nation, and the 2 Apache nations within New Mexico. We primarily focus on community building, policy and advocacy, technical assistance, and training and education. So we do things like certify victim advocates, put on community fun runs, get our local tribal leaders ready to take on violence against women issue on the state and federal levels. And I came into this work not with a background or a heart for nonprofit necessarily, but I think it's about 8 or 9 years ago now, there was a little girl, and her name was Ashlyn Mike, and she was kidnapped from her own community, and just content warning, I think, for a lot of the things that we're going to say up here today, but was raped and murdered. And the person who did it was from her own community. And I think in New Mexico, so nationally we have these rates, right, that these are non-Native offenders who are perpetrating violence against Native women. But in New Mexico, due to some of the tribe's isolated and insulated nature, there's a lot of violence against women by our own community members, and this was one of those. And I have a daughter who's Ashlyn's age, and I remember the day that the Amber Alert finally came out, because it took a couple of days. We didn't have that system in a lot of our communities. I sat down with my daughter and asked her, well, you would never get in the car with someone, right? And she says, no, Mom, of course not. And I said, not even if they offered you candy? No, Mom, of course not. And I said, what if they had a kitten? I knew she loved animals. And she goes, well, Mom, I would just go look at it. And I was like, oh my God, okay. Right, and so then I knew about the Coalition to Stop Violence Against Native Women, and started volunteering, and started off as our office coordinator, and have somehow been blessed 8 years later to be our executive director. So thank you for having me here today.
Thank you, and it's really, really such an honor to be part of this panel and to be with such amazing, strong women doing really wonderful work. My name is Jocelyn Getchen-Kestenbaum, and I want to acknowledge we're in Lenape-Hocking, in Lenape lands, and I want to pay respects to the Lenape peoples, past, present, and future, and their continuing presence in the homeland and throughout the diaspora. And I also want to express gratitude as a non-Native who works on Indigenous rights issues. I really have been informed, and everything that I'm to say, all the knowledge that I have in this space, is really because of and in relationship with all of the amazing Indigenous activists and individuals who I have had the pleasure of working with over the last 15, 20 years in my now approaching mid-career. Oh my goodness. But I just want to say that explicitly that, I want to acknowledge really everything that I do is because of the individuals with whom I'm working, and I want to uplift their voices and really express what they see as the main issues of concern and the struggles, and in any way that I can. So how did I come to this work? So I don't know about all of you in the last session, but for me, law school felt very violent and denigrating in my experience of it, especially property law, especially thinking about Indian law, which I love that Professor Zuni Cruz says there's nothing Indian about Indian law. I found it to be really just disconcerting. And I had worked and lived in indigenous communities in Latin America before coming to law school. And I guess that has also informed the way in which I view the law, because before coming to law, I had a lot of really formative experience in alternative ideas of worldviews and understanding that there are pluralistic ways of thinking and being and interacting with the world around us. And so for me, I've really always thought human rights law was at least the most promising areas of law to practice in. But even over time in working in indigenous rights, it's really where, the most challenging parts even of the law that I had thought was the answer, or at least partly the answer to the struggle of many peoples in the globe, because of really how even human rights law, international law more generally, but human rights law is Eurocentric, is really about colonizing powers over colonized powers and subjugating people. And so for me, I really have come to the MMIP crisis here in Lenapehoking specifically, but in the United States, because I've been working in indigenous rights and in femicide issues for the last couple of decades, and thinking about how colonizing that practice of law is, and really trying on a journey to engage with and learn vertical history where I am, and to understand what the issues are here, both nationally, but also right here where Cardozo law is situated. And so for about the last 6 or 7 years, our clinic has been in relationship with Lenape Center. That was because of a call that I made to NYU, so thank you, NYU. I was starting an indigenous rights class, international law based, and wanted to begin the class the way in which the Lenape would begin anything. And so that began a relationship of, ceremony for that particular class and that particular beginning, but really starting just a relationship without much of an agenda other than let's see what we can do to change the way we think about practicing law and human rights law. And about 6 or 7 years later, now I'm on a working group that they've asked me to be on with several Native activists and non-Native activists coming together to think about the ways in which through law and other things like art and activism, we can be more preventative and healing in the space of the MMIP crisis, that there has been a lot of criminal justice response that has been not necessarily positive for many survivors and their families. And so thinking of ways in which we can engage in the law as a preventative way to keep Native women, men, boys, girls, Two-Spirit, everyone safe before they go missing and murdered. So that has been where I am today.
Thank you for that. This is an incredible panel, and I want to say from my perspective as a former law student that having advocates and strong women, specifically strong Native women who are doing this work on the ground in a space like this is extraordinary, and I wish I had that. So how many of y'all are students? Awesome. We're taught in law school the basics of the law, and we prioritize the law as this thing that will protect folks. And like we heard Professor Fletcher talk about, most times those laws don't protect women, don't protect people of color. So it's been my aim as a professor to enhance and illuminate the voices of Native people, of Native women, and folks doing it on the ground, folks like Carmen and Angel. Because in spaces like this, we tend to uplift those with a JD and an ESQ after their names, but the ones that are protecting our communities and fighting to really make them better are women like these up here. So I feel very privileged to be next to them, to be able to ask them questions and help them share their knowledge as well. And also responding to what you had said, Jocelyn, about looking at prevention and really thinking about the way that we think about law. And because the law is there to fix problems, to put a Band-Aid on something, but really we need to be looking at how do we prevent things like this from happening in the first place, right? And it takes a lot of work, and it takes a lot of rethinking and creating new structures, right? So with that, I kind of want to, for those folks in here that are not familiar with the Missing and Murdered Indigenous Peoples Crisis, I want to ask Angel to give us a bit of background, tell us about the scope and the history of it.
And please, Carmen and Jocelyn, fill in where I am lacking. So the MMIW crisis is murdered and missing Indigenous women, and our organization at the Coalition has shifted, and we're talking about this more as murdered and missing Indigenous people, because we know that the rates of violence against men and Two-Spirit folks are something that we have to champion and respond to as well. So my understanding about the MMIW crisis is that it originated in Canada in the maybe about 2010, 2015, in that range. But it was really this community response calling on accountability to the Canadian government parliament about the high rates of Indigenous women who had gone missing, whose stories weren't being told by the media. And it's really comes from the front lines of pushing back against extractive industries, right? So for all of the things that I think were laid out for us before, when a crime happens on Indian land, in Indian country, we have all of these tribes, but only a handful of them who are able to prosecute non-native offenders. And so when oil workers make their way and are working on the land near tribal communities and they commit sexual assault, there's not a way for our tribes to hold them accountable, right, for these crimes. And so this groundswell happened during this time and has started to make its way down to the United States. And I think for Indigenous folks here, when we're talking about this issue, there's three things that we've really tried to uplift on, like, why does this happen? Where did it come from? And so the first is jurisdiction, the complexity of state, county, like local, and then federal, and then tribal, right? There's just too many opportunities to defer responsibility when there's crime in our communities. And so jurisdiction is one. The second is systemic racism. So for all of the reasons that I think all of us here in the room understand, the way that Indigenous folks in the United States have been treated through policy And so that is one of the issues that we uplift around MMIW. And then the third is chronic underfunding. So the lack of our tribal nations to be able to respond to this, because there needs to be a unique response for every single tribal community. And I think what we have right now and why this has been such a perpetuated issue is because we're all supposed to fit into the same response model on the federal level, and that just doesn't work. So, yeah, if I please add on. If I, yeah.
So when we look at that, Carmen, you work for the Native Women's Society of the Great Plains, and you work with a large area,
Yeah.
number of states in the Great Plains. How have you seen this crisis and its impact within your community and other tribal communities as well?
Well, I think, you really have to look at the historical scope even to begin to understand how big this crisis is. Nobody's really acknowledged it before. Violence against Native women in all aspects of that, whatever you want to call it, domestic violence, sexual assault, whether that's stranger or somebody related, whatever, that's been going on for a long time. I look at our area, my tribe actually right now, the 2 people that are missing are men. And I don't really know all the background behind that, but in some of the outlying areas, there's, you get over into Montana, eastern Montana, where we serve the Great Sioux Nation. That's where we set our boundaries. So we didn't want to be encompassed by states. We wanted to have people that are the same as us in language or culture. Not that we're at all the same, even within the Lakota tribes, but you have to look at what's going on in them places. In Montana, you have nobody responding. They have very little law enforcement. There's a couple podcasts. I heard somebody referring to them earlier about some of the situations there. You can compare and contrast some of the things that happened. One of my friends, she works in a domestic violence program up in oil country, and during the boom time, her friend had went out with some friends and was, somebody found her car. It was still in front of the bar. The door was ajar. Her purse and everything was still in there. Dome light was on, and she was gone, and nobody went looking for her. And it was North Dakota, and it was cold. And so my friend got a search party together, because neither the county, state, or BIA would help out. And they did find her, but it was like a week later, and for some reason there was snowbirds, we call them up north there, and people that pack up and leave for the south during the winter. It was in their house, in their garage, she was found, and she froze to death by then. But why she ran from her car, and there was money in there, so the cops were saying it was drugs. It turns out my friend was like, well, I know exactly how much money she had. She had $1,200. She was engaged. She was going to go pay for her hall the next day and whatever that entailed for her wedding. So they didn't even ask basic questions of her relatives. But at the same time, about about 100 miles east of there in North Dakota, a young girl went missing, and she was 17, within a month of that time. And there was a story about that, how they got their snowmobiles out, and all these people went looking for her, and she was found. She had a little bit of frostbite. But the big difference was the girl whose car was there, and there might have been foul play. I mean, everything pointed to that. She was Native. And this other little girl was blonde and non-Indian. And, just the kind of resources and response that's given, based on people's race. I mean, there's just no other way to say that. And we can talk about that over and over again. You look in eastern Montana, whether it's the Crow tribe or around Lame Deer there in northern Cheyenne, there's so many cases of young women that people didn't look for. Nobody listened. And it did. It resulted in their deaths, or when they were found, there's no investigation. So not only do these families have to deal with the loss of someone, but also the fact that nobody cares enough to do something about their relative that has gone missing. So all of them kind of things really do contribute. Now we have other things going on, other factors that are really problematic. We have a lot of drug dealing in Rapid City, which is off-reservation area, but has a high population of Native people. We have a lot of missing young people, and everybody's fast to say they've run away, but they're not resurfacing, and but nobody's really investigating that or calling that a crisis yet. But again, the resources there are not put towards the Native population. If you look up Rapid City Journal and just see what the response to Native people is. Well, in South Dakota, when you're off reservation, I looked up in Pierre, we have a women's prison. And in South Dakota, Native people are about 8% of the population. The women in the prison are anywhere from 50 to 70% of the people there. So, and a lot of that is, racism, but it's a lack of having anybody represent them. A lot of the public defenders are just kind of making things happen real fast, and it's a lack of resources. I've had some young friends that ended up in federal prison, and they should have never, ever been there. There's so many different ways that our people's bodies are trafficked. And the prison system is one of them in South Dakota, the foster care system. Everybody has a boarding school story. I have three generations of boarding school in my family. And but what we're not saying is foster care right now has more kids than any boarding school. And why is that? And what's happening? And that's why Brackeen is even scarier, because people were hardly following Indian child welfare as it was. And it's crazy. In South Dakota, I'm at this age now where I'm not dealing with my friends' kids going into foster care. I'm dealing with my friends' grandkids or great-grandkids going into foster care, right? And some of my friends, they're not drinkers, they're working, they have their own homes. They can't even get their grandkids out of foster care. It's craziness. It's just craziness. Who wants, after 30 days, the magic number, when I say human trafficking, the magic number is 30 days to 6 weeks. They get their kids back. Does anybody in this room know what happens during that time, why that's an important number for the state foster care system? Yep, that's when the federal dollars kick in. Yep. Follow the money. Always follow the money. Mm-hmm. It will tell you a lot of things about what's happening with our young people's bodies. Mm-hmm. So all of that kind of stuff leads to missing and murdered. And foster care. Foster care breaks relationships. I mean, and with Lakota people, our whole language is about relationships. Anybody here know what the fastest growing vocabulary words describe in the English language? Money, fiduciary things, I don't know. I can't even keep up with it. But in Lakota language, it's about relationships. You have a different word for your older brother, you have a different word for your mom's cousins and your dad's cousins. It's all about relatives, right? So that's what you can tell, that was what was valued and what still is. But what happens with foster care is these kids get kicked out on the street. There's no independent living resources, nothing. Once that money from the federal government quits coming, these kids are out on the street. That is a result in people being missing that aren't even known to be missing. They found one young woman down in Pierre, South Dakota, fished her out of the river in her car. She'd been gone for a year, and nobody reported her gone. She'd gotten out of foster care, she'd gotten a job, but whatever happened there, her friends thought maybe she went back to the res. Her family didn't know her anymore. There was no connections. So, I mean, there's just so many factors. And then prison, coming out of prison and going into the halfway houses, that's a whole nother problem. So it's not just a reservation problem, it's a problem pretty much nationwide. Mm-hmm. I think one of the first studies that showed us that was back in '96. They had a Department of Justice did it, and I can't remember how they gathered all of their stuff. I think it's phone calls, but they weren't even looking at reservation numbers because that didn't even come in. But in urban areas, the people most likely to be victims of homicide were Native women. And everybody was really per capita. You know, that was like, and the thing that a lot of our tribal leadership likes to look at when they talked about that was that the perpetrator was usually somebody of a different race. But in our own communities, what we need to own is that the perpetrators are most likely, except maybe in oil country, they're our own people. You know, we've learned these lessons well. And we talked about if we're going to have questions about something that we don't want you guys to save them to the end because we might forget what we talked about.
Yes.
At least me. So I think everybody was good with having a question as we're going along. But I hope that gives you an idea of some of the factors involved in how we are having this crisis out in our area anyway. And it's hard for me to talk about Angel's stuff. I know perpetrators for a long time, if it was a really cold winter's night, they could leave somebody out in the cold and then she died of natural causes and nobody would ask, well, why is she in the middle of nowhere? You know, and she froze to death. And I was saying to Leanne Guy, who's from down in the Southwest, well, at least you guys don't have that going on. And she's like, did you ever have somebody get left out in the desert with no water? So still natural causes. Anyway, I can go on all day with all my stuff. What's the next question, maybe?
Carmen, I think you've really illuminated that there's so many ripple effects of history within this country that have caused a lot of social issues that have led to the MMIP crisis. So I want to direct this question at Jocelyn. So U.S. Law and policy has played a central role in exacerbating this issue, especially with regards to jurisdiction. Angel touched upon it very briefly. So we have legislation like PL 280, the Public Law 280, Supreme Court decisions like starting with Oliphant. So how really can you tell us how U.S. has tied tribes' hands in addressing this issue? And also, I want to have you also bring in the global perspective of this pandemic, because this jurisdiction issue, this lack of power in doing anything is not isolated here to the U.S.
Yeah, thanks for that question. So I come to this issue from an international law perspective, and I work on genocide prevention. And one thing that I understand in the genocide prevention work is that genocide is a process. It's not an event, as much as law would like us to think, and it's very selective application. But it's a process, and in this country, something we really have not addressed in any real meaningful way is the many genocides that have been and continue to be perpetrated against Native people in this country and Native tribes. And for me, it's processional, and it continues with settler colonialism. It's a very active process in and through the law. So all of us who are learning law, from my perspective, settler colonialism is a way of setting up and organizing the colonized state, and our law that we learn in law school, again, tribal law or federal law or state law, all of these areas or, bodies of law are the continuation of conquest and colonization against Native peoples in this country. And you can see that Sarah Deer is an amazing professor of law who has really laid out the case about conquest and the violence against the land and connecting that violence against Native women. And she's drawn this beautiful thread. I mean, it's not beautiful, it's terrible, but the way in which she has explained it really resonates with me in the way that I have seen violence against Indigenous communities, the raping of the land comes along with the raping of the women, and it's interconnected, intertwined. You cannot really think about these things as not interrelated. And you were talking about the issues of extractivism. Extractivism is capitalist, racialized capitalism, and we're at that late stage. And in Lenapehoking, we often are talking about the fact that this is really the first landing. This is the ground zero of conquest. And even in these urban spaces, when we see things that we call gentrification, are really continuations of urban extractivism. And we're still seeing violence against the peoples of the land, often not indigenous because they were already dispossessed and forcibly removed. But that process continues. So that's how I approach this work, is thinking through the lens of genocide and genocide prevention. Now, genocide is not even the word that Native peoples probably would use to describe the violence. And so I say that from the colonizer's law as well in international law. But if you just think about this as a continuum of violence and how it plays out now on tribal lands and also in urban spaces against indigenous peoples, it is still ongoing. And, we talked about Oliphant. That particular case has been very detrimental with regard to jurisdiction. We talk about jurisdiction as lawyers, but what this really means is impunity and a target on Native women's backs in Indian country, that non-Natives can come on to Indian country, perpetrate violence against them, and likely get away with it. That's what Oliphant said, and there have been fixes, but those fixes are not foolproof. As the previous panel was talking about, there are still loopholes. There are some gains through the VAWA Act and the Reauthorization Acts, but it is not a full fix. That is where a lot of tribes and advocates have been putting a lot of attention and efforts. Whatever we do in this space, from my perspective and from the advocates with whom I work, we need to forefront self-determination and sovereignty issues of tribes to be able to reverse what I see as the ongoing colonization of Native peoples here in the U.S.
So you mentioned the reauthorization of VAWA, the most recent of which was passed in October of last year. And so we're going to stay on this law tangent for just a little bit. It's a step in the right direction, but we all know it doesn't go nearly as far as we would like. So what are those shortcomings with VAWA? And is there anything that you know of that's being currently done to address the gaps with VAWA? Anybody? No?
Well, VAWA first got passed back in 1994, and it was, way smaller than what it is now. I wrote my first VAWA grant on my kitchen table after my kids went to sleep. In those days, laptops didn't have internet capacities, but you could at least take them home and get some work done. It wasn't until 2005, I think, that there was actually a Title IX, which was strictly for Natives. There were things that got put in there that made crimes of things that, activities that had not been before. 2013 was a real landmark. I'm trying to do the real Reader's Digest version here. Was a real landmark year in that was when we first got the jurisdiction over non-Indians when it applied to interpersonal relationships. Very few tribes have implemented that, and there's been different activities or stipulations or grant funding to overcome some of the problems. Like a big problem is most of our tribe couldn't afford it. Like when we have our own tribal members in our jail, if there's a health problem, they go to Indian Health Service. It doesn't cost the tribe anything. But if it was a non-Indian, it would break some tribes to provide health care to them if you're keeping them in jail. So that was a big barrier for many tribes. Just overcoming, you know, all of these years since they had jurisdiction over non-Indians. We have here's a little selling point for anybody that's wanting to get an easy job, or you know anybody. Our tribe right now has so many openings. You know, we have the opening for the prosecutor, attorney general. I think we have 2 judge positions open right now. And we really do need a lot of trained people if we're going to have this system that's recognized. Even contracting with tribes is another way of being able to meet the criteria for there's so many hoops to jump through to be able to arrest a non-Indian. And you have to have a lot of trained judge, you have to have a lot of trained public defender, you have to have a jury of your peers. So we've got to take I don't even know how we're going to do that if we ever implement it, Cheyenne River. Rosebud is on the cusp of getting it done. I think there's 3 tribes in our area that have gotten it done. Fort Peck has done an amazing job up in Montana. Standing Rock has done a few cases. They've gotten it to go through, and Sisseton, Wahpeton. And mostly it was because there were some young lawyers that really pushed it and did the writing and got things happening there. But in the newest one, because there are some tribes that have been doing an amazing job of implementing it in Washington State and down in, is it Arizona?
Pasquayaki.
Yeah, say that out loud.
Pasquayaki.
I always say that one wrong. Yeah, I have a hard time. My daughter teases me about being a second language speaker, speaking English, which is not my second language. But anyway, they have done an amazing job, and they keep finding these holes. Like if in over 50% of the cases, the statistics show that if somebody is beating their partner, they're probably beating their children too, and the tribes could do nothing about that. Again, when they were arresting people, if they beat up the law enforcement officer or the detention officer, no jurisdiction on any of that. So then were some of the things that got changed in the last one, in the 2022 one that was just passed, and so they have jurisdiction over those crimes, but only if you have met all of this other criteria. And you know, it was very aggravating. I worked in our shelter program at Cheyenne River for 17 years, and the only thing law enforcement could do is bring the victim. If the perpetrator was non-Indian, the only thing that could happen is that the woman could come into shelter, and he got off scot-free. And that was because of the, I was surprised nobody talked about 7 major crimes.
Yeah.
The way Lakota people saw justice was way different than what we have right now. So when we talk about Indian law, I really think we need to find a new way of talking about it, because Indian law has nothing to do with this system. In the 7 major crimes, one of the other Lakota tribes, I always tease some of my friends down there, about how they lost jurisdiction for all of us, but they were practicing, you know, a Lakota value system. One young man had killed another young man, and you replaced a relative or you replaced something for that family. That was the way that they did things. And the non-Indians looking in at that were like, these people are so stupid, they're so ignorant, they don't even know how to punish murder. You know, so that's how the 7 Major Crimes Act came about, and that's the Spotted Tail case. If any of you legal minds want to go back and look it up, I just know the story. I don't really know the law.
And Carmen, what about sentencing too? Because I think that's important, right? To think about
how you
sentencing.
sentence. Yeah, yeah. I mean, that would be a whole different thing. You know, you might have to somehow, if you murdered somebody or caused somebody's death, you might have to replace that person as a relative, because again, relatives were important people. That was a currency almost, the economic kind of system. There's just so many things. And as you're studying law in Indian country, maybe that's how we should refer to it. law on our own terms, you'll find that a lot of the law has been shaped by the violence against Native people. There's one of the cases in our tribe, it was a tribal member went into the legal aid office and raped a woman, and it happened to be on fee land. So then it went to state court. He was found guilty in state court. He appealed, and it went, and he said they didn't have jurisdiction, and it was found that, yeah, Cheyenne River, because we were over 50% either Indian-owned or in trust property, we have jurisdiction from border to border. Now, that isn't true if you go just to Sisseton, another Dakota tribe across the river, or even at Rosebud. One of the first cases I was advocating on and worked with a family, a little girl had been brutally raped by her stepdad, and it had happened in Millette County, and it went to federal court, and he was found guilty. And then they figured out that the rape was actually on fee land, so that whole case had to be retried in Millette County, where he was found not guilty. And this didn't happen overnight. I mean, it took years. So, there's just all kinds of jurisdictional problems, and what does that happen to families, and what does that mean on an individual thing? I sit in different law places over the years. I'm kind of getting long in the tooth now. These guys were saying, well, is everybody a mom? It's like, I don't know if I'm a mom anymore. The kids are long gone, but but that's what we're supposed to do, is rocking them out, right? So when we sit there and we talk about these cases, what does it actually mean on an individual level to the people? Sometimes it's just been horrible, on people's mental health, even on their relationships with other people. And there just isn't, like trying to get women to safety, which was my job for a long time. There isn't safety.
Mm-hmm.
Yeah.
I think, Carmen, you highlighted the great irony in this work, at least with the law in this country. The U.S. government, along with tribes, after they've been saying for years, we need to fix Oliphant, we need to have some jurisdiction back, some authority to keep our people safe, but not before the federal government was like, hold on, you have to look a lot more like us. Mm-hmm. You have to have a jury of your peers. You have to have this protection. And now it's even funnier after hearing Matthew Fletcher talk about what equal protection is and equal rights, right? So in order for tribes and the federal government to address this gap, this community safety issue, because of the way the U.S. government set things up, or the box that they placed tribes in, they said, look more like us first, and then you can start addressing these issues and having jurisdiction over non-Native people. And I find that so ironic, because you understand that your system wasn't good enough, but yet you want us to have that system, to mirror that system. And then you talk about the spotted tail case. I think that's Crow Dog. Mm-hmm. And
I'm used to victims.
No worries. They talk about restorative justice. They talk about how tribes, how we used to resolve our own conflicts. And it wasn't just surface level, it was getting down to the deeper issue so that these things didn't keep coming up. And that's difficult when you talk about violence. It's difficult, especially when you talk about domestic violence, because then you have this understanding, right? You have to make sure that the victim is safe, right? They weren't feeling safe before, but then how do we then talk about restorative justice? Mm-hmm. How do we talk about tribal justice apart from the legal remedies? So let's kind of shift our conversation, and focus on these tribal responses, these community responses, and really look to responses that places like the Coalition to Stop Violence are doing, because we want to talk about how do you heal these communities, how do you empower them, and how do you prevent something like this from violence against women.
So one of the tenets of how we work is the solutions to violence exist within the communities themselves. And so it's working alongside the community to uplift some of those traditional knowledge systems, the ways of knowing, ways of being, because to your point, right, VAWA can only be adopted in a community if it completely takes on a Western model of justice. And in New Mexico, that's not going to work for some of our smaller pueblos who are very traditional and will never take on a Western system of justice and shouldn't have to in order to provide safety for their women and children and vulnerable in community. But just regarding MMIW, some of the things that our coalition is working on right now, because we don't provide direct service, we're working with the folks who are working with victims. One of the things that we've done is started to develop a core advocacy training for MMIW advocates. So we know that a lot of folks who want to be a part of this kind of work in this movement might not understand things like a trauma-informed approach or full faith and credit, what that means, right, with protection orders. And so it's really getting community advocates ready to work on a system level with families that are impacted. We also have a storytelling campaign right now. So all of the wonderful responses around MMIW, be it Not Invisible Act or the Savannahs Act, really are addressing system level issues, non-communication issues. And the families are largely forgotten from these conversations. So it's like, how do we get the BIA to talk to the FBI and DOI to talk to DOJ? And it's like, wonderful, right? I'm glad you guys are figuring that out. And our families are still left behind in these conversations. So we have a small little pilot project that we've been working on for a couple of years. It's just direct assistance to families who are experiencing MMIW. And the things that they need are lodging. They need to be able to access a hotel room for a couple of nights while they're doing searches. They need printing for signs when they attend rallies. Some of our families need to get their things out of pawn, right, to have ceremony. And so it's just these like really basic needs that are still not being met for the families who are experiencing MMIW crisis. And then the last thing our organization is doing is really trying to address the non-response from media and police, but especially media, right? So I think there's been a groundswell of awareness around MMIW crisis, and what we've noticed is that media is willing to talk about this as an issue, right? Like, what's the issue? What is MMIW? But our stories still aren't making their way into media, right? Because we're doing a lot of victim blaming. She ran away, this isn't a crime, those kinds of things. So we're working with families and advocates right now on storytelling campaigns. So how do you draft an op-ed? How do you actually get in front of a camera and have an interview in a way that tells your story and can promote visibility for your family? And then the last thing that we're working on kind of on a system space is one-on-one, I guess technical assistance, maybe you would call it, with law enforcement. So more often than not, when somebody's reported missing or there's suspicion of maybe homicide from a family, when they interact with the police or a detective, they get this, right? This isn't a crime. Maybe they ran away or they have a history of, substance abuse or use. And so we've been working with law enforcement to initiate every single one of these situations as a crime so that they have a world of access in terms of like victim compensation for the family, the amount of resources that are available to that police officer or detective. Instead of working your way up to murder or a crime, that you start, that's the baseline, so that you have more access to the system response that you need. So those are some of the ways that our organization's been working on the issue.
Great. And Carmen, with your organization?
We have a really wide area to cover. One of the things with tribal coalitions is we each get the same amount of money, no matter how many people we serve or how big of area we have. So we're not based in any kind of urban area. I don't think there's anywhere in South Dakota that's actually even designated urban, but we try to help families in referrals. You know, there are some programs in different parts that are helping families. Our funding doesn't go as far as the things that Angel's talking about that she's able to do. We do a lot of awareness activities, which really seem like it's just not enough. We have gotten some things done on the state level because a lot of the situations that are really problematic are in state jurisdiction. So we have set up things at the capitals in Bismarck and Pierre in Montana. And the people that we have come and talk on the issue are the lawmakers, because we want them to start being able to articulate some things that need to be done to address the problem. We have been able to do that. Everything we're doing isn't enough. That's pretty much basically what I can say about the MMIW situation. We try to help each one of our programs, because that's who we support, is the programs on the ground, and we have 25 programs in tribal communities right now. Help them to address the situation. The first week I was on this job back in 2006, there was a walk for a woman whose family had went out to find her, and that was in Lower Brule, Vicki Eagle Shield, and she had been missing, and they kept calling and asking the police to help, and the same story, nothing happened, and family and friends went looking for her, and she was found in a culvert, and she was naked and decomposed. But a year later, we were having a walk and an awareness, because to this day, nobody has been held accountable for her murder. And after I got back from that, I went and got posters and signs and, helped get the drum group together in a feed and did all of the things. And then I found out that was not an allowed cost under our funding source, because, we had 4 crimes that we could address at that time. And all of them, there wasn't any evidence. They said there was no crime because nobody had been charged, and we didn't know who her perpetrator was, so it wasn't like domestic violence. It was just craziness. So anyway, since then I do have funding, so I can just say, it's violence against women. And what we ask our programs to do is every time this happens, to go like it is a relative that lost somebody. If somebody's missing, go as soon as you can. Take food to the family, do something, and just say, we're here for you. Do you need help calling law enforcement? Do you want to get this on the news? Can we help you with that? And then if the programs call us in, we try to help with those kinds of things. But there needs to be a more immediate response, and so a lot of our training and support to our programs is helping in that.
When we talk about and we look to these communities, you had said that there's just not doing enough, and that's not for a lack of trying. It's funding. If anybody's familiar with the federal grant process, it is horrible.
And that's if you are federally recognized, right?
Yeah. I do a lot of work with substance use issues, and under the previous administration, words such as evidence-based and trauma-informed, we weren't allowed to use anymore. So it's really the issues that are identified, how we're able to talk about it, what issues are funded. It's all dictated by those up high. And it kind of make communities feel really powerless. So how do we, and you guys doing the work, ensure that voices of the tribal communities are heard, their needs that they've identified themselves are prioritized. So again, brought back to what Professor Fletcher said, once you hear tribal politicians start talking about tribal sovereignty, the need to exercise it, you know that they're not speaking for the rest of the community. So how do we ensure that we're listening to the community?
And, well, for me, I really think that it should be the families that are speaking about this, people that are actually impacted, and how they are impacted in different ways, because that is the most powerful. I mean, there's so many documentaries now and podcasts, and as I listen to them, I can, tell the difference between somebody just trying to garner attention for themselves and their amazing abilities to somebody that's actually listening to the community, because they have community voices in there, whether it's, the agencies that are responding or not responding, are the families especially, what has happened from their perspective. I think that's what's really needs to be, what tells the stories about where the system gaps are, what isn't working. There's something more to say on that.
Well, my personal, coming from Pueblo communities, right? We don't have women in a lot of there's not a way for women to be in leadership positions in our communities. So I think part of system change is Indigenous women in leadership positions. I think that's an important piece in protecting our communities. But the other, how do we ensure that our communities are listened to by the folks who are in power right now, I think comes with relationship building. So right now our MMIW task force in the state of New Mexico is housed under the Indian Affairs Department, which is a cabinet position within the state government. And our current secretary designee had a rape charge in 2007 and went through 3 years of motions and was ultimately dropped in 2010 because there's the lack of evidence, which is exactly why the declination rate is so high for sexual assault cases across the country. And we know this as advocates, right? And we've been pushing back against this. And the reason we were able to keep it from a full designation, though the governor of the state of New Mexico stuck by her decision, was because of the relationships that our organization and others doing this kind of work had built with tribal leadership over the years. And so in New Mexico, there's a council called the All Pueblo Council of Governors, which is a council of all 19 tribal leaders, and we went to them often and asked them, right, for their help and their support. And I really believe that 20 years ago, if we came to them with this issue, it's not something that they would champion or even listen to, or a conversation that they would have amongst themselves. But in meeting with the advisory council this past year about this issue, they had this conversation. They sat down with the designate Indian Affairs. They sat down with the governor of the state and really were championing this issue finally, right? And this is the work of our aunties or grandmothers of generations before us that brought us to this point. And so just remembering, though, that these are relationships. This is how we get change accomplished, is through real relationships. And so we had our Tribal Leader Summit last week, and the chairman of, we had a panelist, right, say to the crowd, where are our tribal leaders? This is a women's issue. This is being championed on the shoulders and the backs of women. We're experiencing it and the ones having to address it. And our chairman of APCG stood up and said, well, you need to invite us to these conversations. You need to acknowledge, right, that when we do show up, we're here. And so I think that was a really humbling reminder for so many of us. It's like, yes, we can tear down our tribal leadership, but we also have to be willing to build relationships with them and uplift that leadership when they do show up. Yeah.
I think for an issue like this that is so emotionally charged and really takes a lot of soul and spirit work, that's when it's really important, just like you said, to lean on other people. It's so easy to get frustrated and make up your mind that somebody in power doesn't care, right? But just like a lot of the work that women do, we kind of just need to suck it up and keep on moving, raise our voice when needed, but also show a lot of compassion and nurture those relationships, because it's this work is important and needed, right? So kind of moving back now and looking as we're wrapping up, looking at the work that is that we need to heal society, right? We're just a violent society, and just like you were saying, the law is violent. And in my class, I teach about how the ebbs and flows of the society values really inform the type of law that gets passed, the type of policies that get implemented. How this is directed at you, Jocelyn, in your work in genocide prevention, atrocity prevention. What do we need to do as a society to prevent all of this, to have the end of this MMIP crisis come quicker? How facilitate that? I'm not too sure, but
how to undo
yeah.
500 years of colonial conquest. Yeah, no, that's a great question. And I think for me, at least, I mean, just coming from the experience that I've had is to recognize that solutions come from the communities themselves, and recognize that we're not going to solve this problem with Eurocentric worldviews, that this is how the problem has come to where we are. So my thinking and the thinking of the people with whom I work is that whenever we can, we need to infuse the work that we're doing with Indigenous values and worldviews. And I've been thinking about this a lot lately, and I've been trying it out. So I can give you some examples. So in the clinic, when I'm working with Indigenous partners, I am focused on the process. I am focused on the relationship. The relationship actually, to me, becomes the work. It becomes the important human rights work that I'm doing. And in many ways, the process leads to the solutions that are driven by the communities themselves. And that, for me, means rethinking how we teach law and the practice of law. I stopped calling soft skills soft, because these are the skills we need in order to get out of this process that we're in right now, this very structurally violent place that we're in this country. And the soft skills like empathy, like collaboration, I find those to be the skills and the most important skills that I want my students to leave clinic understanding. Also, the terms like allyship, while important to think of allyship, Native communities have told me they don't like that word. That allyship, in some way, it presupposes that we have these, parallel but separate interests. We have to think of each other as kin, and we have to take the idea of kinship like, oh, we're all wrapped up in this whole future together. And when you think about things like climate justice and extractivism and MMIP crises, yeah, we are all in this together. What is, harming one of us is harming all of us. And to really start rethinking from that perspective what kinship actually means. And I think what Carmen was saying, it means calling someone and saying, do you need me to bring you food? What do you need right now? Right now, because there's crisis after crisis in the communities in which I'm working. And to me, that means we must slow down. In times of crisis, the white supremacy culture that we teach through law makes us speed up, and that's when we forget about how important relationships are and how important humanity people and the people that we care about are. And I understand that we're all lawyers and, we have to be very professional, but question what that actually means. I mean, we are in relationship with each other. And that's what I've been experimenting with through the lawyering that I'm doing in Indigenous rights work. So far, it's been really fruitful. And, right now in Lenape-Hawking, we have, in thinking about prevention, we have a data problem. And even the collection of data can be another one of those institutionally violent processes where Native people get erased, especially, in an intersectional way, Native women, Two-Spirit. I mean, we see the other category as the category for everyone in this MMIP crisis. No, that's just how we further erase Indigenous people. So the data problem is something that we've been focusing on. That's where FOIL requests, like the lawyers that we're working with, that's where we can bring our skills. But that problem and the solution are coming from Native community members themselves, and data sovereignty is then what we're focused on. How do we ensure that whatever we are collecting, whatever data we find, is owned by and it resides with the community and the people about who this is all about, right? So I guess I could say so many different things about how we need to change the way we practice law, but I'll leave it there, and maybe we can talk more about how to actually implement that in law schools.
Yeah. No, thank you for saying that. I feel like you touched on a lot of things. I am a huge advocate of using data for tribal solutions. Something that is very difficult to work with. It's very difficult to make exciting and sexy. But I think it's really important because we all work with grants and trying to get grant fundings, and to tell a story through numbers is incredibly difficult, especially when the people that are reading those grants don't come from our communities and aren't really understanding our stories. So as we wrap up, Carmen and Angel, you guys both do incredible work. You guys hear and hold stories that weigh on your spirit. You guys see the communities back home, and it's hard, right? Can you just share with us and myself, because it just, I don't think I have the enough skills to really deal with this from time to time, but like, how do you take care of yourself, and how do you take care of your communities from getting downtrodden and pessimistic?
Well, I don't think I do enough. Obviously, I get really sarcastic when that's happening. I know I need to go do something. Occasionally, I go to sweats, but my biggest self-care is just to be in the middle of nowhere. Mm-hmm. If I have horses, I still live within a mile of where I grew up, and I can get to the middle of nowhere in a real short time. I live in the suburbs of Greengrass, South Dakota, if anybody knows about that area. But, we talk about this a lot. There's just so many things. Taking care of the advocates in the programs, that's really a priority. You keep hearing about self-care, and all of you are probably going to be in places where you need it too. I mean, you're going to have cases or situations that are just going to tear you up. And one of the things that, you used to hear about this breathing. I used to be a CPS worker. I had really good speakers, and I would almost always have a migraine at the end of those days. There was a no-win situation. I would play hard rock for 20 miles. I drove home, and my headache would beat in time with that, and it would be gone. This thing about listening to trickling water or whatever makes me want to scream. But one of the things I learned this last year was about breathing. When you are a victim, or you are in crisis, or court maybe is going to throw you off or whatever, you don't breathe. And I've lost so many friends to heart conditions and diabetes. And when you don't breathe, it takes so much out of your body. I know that sounds so new agey, but it's actually a physical thing that we have to remember to breathe, and breathe deep, and take care of our bodies. That's a big thing. In Lakota culture, the first medicine is water. Yeah. But two things too on tribal response. I had written notes before I came, and I never bring my notes. But it's kind of like my grocery list. At least if I wrote it down, maybe I'll come back to it as I walk around the grocery store. A couple things that have come back is banishment. You know, that was a traditional thing that we did. And like at Cheyenne River, where I live, we've banished anybody that's been convicted of a drug deal, whether it was federal, state, tribal, any other tribe. You know, if they have it, they're banished. And we have a big list now. It really hasn't helped the problem that much, but, you know, at least it's there. I'm working with Northern Cheyenne right now, and they're working on a code. They just banished non-Indians. It's much easier in most of our tribal codes to banish non-Indians than members. But he was a pedophile, and he had perped on several of their children, and they banished him. And now their tribal council, which is mostly women, they went, why would we only get rid of non-member ones? And they're working on a code to banish all sex offenders from their grounds. And I think, you know, we really need to be talking about the violators. In order to have this many victims, we have to have some perpetrators, and then perpetrators, to get away with as much as they get away with, they have to have some supporters. When I worked in the shelter, I would often tell my staff, we don't got to worry about them perpetrators. They're usually only beating the women they love, right? And they don't love us. But who did we have to worry about in our communities? I grew up like this. If somebody bothered somebody in my family, we were like a pack. You know, we turned into a pack against that. And that's been a survival tactic, you know, for many of our people. So the people that did bother me is I had a grandma almost try to run over me. She was grandma to a perp. I had problems in the store. I had someone calling me an effing liar while I had my kids with me. I was just like walking in real loud. I was like, just don't pay any attention to her. She's crazy. Yeah. But, you know, just trying to keep a perspective for my kids. But, you know, those are the problems that we have in our communities, is the support for the violators, and they get it from their families, they get it from the system, and that's what keeps it going. I'd say that about tribal responses.
I appreciate that. Yeah, Karma, I also believe that, like, if we tore this whole thing down and rebuilt it, it would have to be around the people who are causing the harm.
Yeah.
Right? So, I moved home. Well, like, Albuquerque's not a big city, right? We're in New York City. It's our biggest city. And, I moved back to the res, and that's been really grounding in the way that I regulate myself and able to carry on the work. We live in the house that my husband's grandfather built, and that makes a difference, right? Memories hold places. And I think the most fundamental way that I care for myself and I'm able to carry on is for, like, Isabella and my daughter, right? That there are little ones looking toward all of us to carry the work forward. And I appreciate the land acknowledgement, but it's like always remembering, that the land that we're on right now has known more love, liberation, and freedom than it's ever known this colonization. And those are the people that we come from. And so it's remembering that, right, that we belong to decolonial systems, and we're still connected to those systems.
Jocelyn, do you have any self-care tips and keeps you grounded?
Yeah, well, breathing, I like that. I do a lot of yoga. That's the self-care. But I think also community care, like caring for one another and recognizing that, you know, we don't have to always have everything together, and we can also support each other. I think that there's something about legal training that makes us feel like we can't bring all of ourselves into the work. And so I think the more that we can be authentic and show vulnerability, this is hard work. It's, I think, healing in some ways. And me, you know, I'm an educator, and so I'm trying to also model what I think the practice should look like from an authentic place, from a place that is caring for each other rather than, you know, just caring for myself, although you have to care for yourself too. And then I just would say also Nichusak means my women friends, and it means women talking to other women. And I think in spaces where we can hold each other up, women in all their intersectional ways, I think that's when really great things start to happen, because that's also a system of oppression that we need to unravel through a lot of work and hard efforts in and through law. So I'll stop there, but I think this has been really such a privilege for me to listen as well. So thank you to all of you.
Great. Just want to thank you all for just sharing your knowledge, being here with you, reminding us that like sometimes the law can feel impersonal and not built for us, but there are still some people that are trying to fix it, and we're going to keep trying, right? And we're not in this alone. So before I wrap up, I want to make sure I answer any questions you all may have, and also our panelists can also answer as well. Yeah, go right ahead.
I'm going to try and use the mic. Okay, hi. Hi, well, thank you all so much for what was an incredible panel on what is also a very difficult topic to speak on, and really painful and upsetting topic. I wanted to see if folks like perceived any sort of tension between the really necessary movements to center MMIP voices and needs under VAWA, and the way that it also kind of expands the carceral state, and how do you kind of square those two?
I mean, I can just start. I definitely feel, so I'm an international law expert, but I also deal with atrocity crimes. And so thinking about the carceral state from the international level. And I too think that a lot of the focus on investigation, prosecution, punishment really overlooks, I mean, think about the carceral state and the criminal legal system as really not centering survivors. And for me, that has been the hardest work, is to try to shift focus in the international space away from criminal legal responses, because it doesn't center and elevate the voices of victims, and it certainly doesn't lead to, in many instances, real reparations and redress for victims. And so I would encourage all of us who are thinking about responses to think about alternative responses to the criminal legal system, whether it's domestic or international, because these are also systems that are designed to keep the overall structural violence in place, right? They pluck out the bad actors, but they do nothing to transform systems. And so I really encourage the young lawyers out there to think about where the law is potentially transformative, and go there and try to change the systemic issues, because otherwise we're just, throwing those sand dollars back in one at a time and not really doing anything to change these systems of oppression.
I got to be part of our code development back in '86, and it's a very bad code, so I'm not using it as any kind of model. But one of the things that was in there, and the basic, like when domestic violence was the focus, is that most offenders have learned this behavior, and the most hopeful thing is that if something can be learned, it can be unlearned. And so part of our code was that they go through intervention, kind of like, what do they call it, a diversion kind of thing as part of their sentencing, and if they finished it, they didn't get jail time. I had to help with some of those groups. If you have a psychopath in there or somebody like that, it kind of screws up your group. But for the most part, they worked. And there's some research, well-like research. It doesn't really matter so much about what it is. At that time, I thought you had to follow this thing, the Duluth model, and that was the terminology at the time. And I helped this older traditional man up in Standing Rock to get his group going, and he went to our training, and he had the whole curriculum, but he didn't follow it. It just drove me crazy, so I'd go up there to help him. He'd ignore me, and he'd go ahead and do his groups, however. And then he, at the end, most of the young men, he would give them a gift of a toolkit, a pliers and screwdriver, hammer, I don't know, a couple of things like that in there, because, you know, he was talking about, like, you know, previous he would have been giving them something to hunt and to provide for their families, but now, you know, it might be helping around the house, and that this was what men do. You know, you take care and nurture your family, and I think that needs to be the message, because, you know, it has come out in the research that as long as there's some kind of a learning system going on, and that there's an intervention, and that there's going to be backed up by jail time, that a lot of times these programs can be successful. And it's not so much about whether you use a Duluth system or whatever, but it has to be a lengthy time. But and at the time, I know, see, my sarcasm was already heavy by then. I was talking to our tribal leadership, and I was like, you know, this is one of the most loving things we can do for our young men, rather than sending them to prison. They thought I was being sarcastic, but I really was. I mean, you know, I have nephews, I have a son, and I would rather that they unlearn bad behavior than go to prison, right? So I think that, you know, we have things within our programs. Some of the men have come up with some intervention programs where sweats are involved, and the T-shirt I have on today, our first teaching in Lakota society, is from the White Buffalo Calf woman, and even thought you respect women. That story where the two guys go out to meet her, and one of them has bad thoughts and he gets turned to bone and ashes. But anyway, that's a whole nother story. But that's one of our first teachings. So even in thought, you respect women. So if we can bring some of that back.
Great, thank you. Thank you for your question.
Yeah.
Well, and I just want to add a little bit to that for all the lawyers and law students. You know, the idea that the carceral system was even designed for rehabilitation or anything else other than retribution and punishment and control over mostly Black and brown bodies, that is something that, you know, we just all need to have a reckoning with in this country. And so the idea that we could have a system that we rethink that is actually rehabilitative, that's another way that, you know, we need to start imagining what we want and build that, because it's not just going to happen. It's gonna take all of us rethinking what how the law should be serving us, all of us.
Thank you. Yes, sir.
Hi, thank you. I want to just speak in generalities here. With this issue of violence, murder, human trafficking, do you have any data on the perpetrators with regards to Indian versus non-Indian? Our perception out there, the general perception is non-Indians coming in and perpetrating this violence on our Indian people, whether it's in Indian country or not. But I'll just say I know for a fact that there is a lot of Indian on Indian crime going on. What are the percentages out there, and is the enforcement approached differently?
I don't have the figures on hand.
Yep, so I think a lot of the data that we rely on as tribal coalitions is DOJ, NIJ, right? And those are the stats that tell us that it's non-native perpetrators. But I mentioned earlier, like in New Mexico, we're very isolated and insulated as tribal communities, and we do know and hear stories. The overwhelming majority is native on native crime, and especially when it comes to intimate partner violence or sexual violence in our communities. And so there isn't anyone collecting this data per se. We do have a state sexual assault coalition that's put out a handful of reports that do underscore that it is happening within our own communities. And I can tell you from firsthand experience, when we take that information back to our tribal leadership, there's a lot of aversion and pushback to, well, that's not what DOJ is saying, right? And they don't want to face the fact that this is happening in our own communities. And so how would the system differentiate our response? I think it's incumbent upon our communities to create our own solutions for this, especially when it comes to, where I think we're talking a lot generally on intimate partner violence between a man and a woman, and we're talking generally about a man perpetrating, right? But I think if we go back to some of our really traditional teachings around roles and responsibilities in our communities, that's where we can hold a lot of these in the unique responses that we need on a community level. So there's not a lot of data out there. What we do have that tells the story that we know in our own communities and our own families, people don't want to hear it, that are in positions of power right now, but those are the ones who we need to champion the solutions.
Mm-hmm. Well, I would say government data collection is an inexact science, and sometimes you can't rely on it. But is it also your perception that there is a lot of crime that is underreported or not reported for many different cultural reasons, or, you know, the whole family shame thing? Mm-hmm. So they try to keep it within and not let it get out there. Is that something that's significant?
Oh, definitely. One year, just to show you how much isn't prosecuted, Rosebud had a grant, and they got their community going. They had lots of policies, collaboration, coordination. And so one year they collected this data about how many people had called in, and there was 200 and some sexual assaults. I mean, and that was across the board, men, women, children. And then out of that, I think it was between 80 or 90 actually went in and got a sexual assault kit done. And out of that, maybe 40 or 50 reported to law enforcement. And out of that, I think there was 6 that were prosecuted and 3 that were actually adjudicated all the way through the system or found guilty. So that was just one little synopsis of one tribe. The other thing is with BIA, Bureau of Indian Affairs, who does most of our policing out in our area. I can't speak for other areas. You guys got mostly BIA down there too, huh?
It just depends on the tribe.
Mm-hmm. Okay, yeah. And so like our tribe, where I'm from, we have some in our constitution where we can't have anybody but our own tribal police department. And so we do a 638 contract through BIA. Anyway, it was a year Cheney was in there. It must have been back in 09 or 10. But we were asking for these figures. We wanted them too. And so, oh yeah, he said, no problem. And so then we were at this tribal consultation, and we're at tables full of different tribal people, and he hands it out. And Cheyenne River for 5 years had no crime. Just because nobody was collecting on us. I was like, look at all you bad people. But in BIA, their crimes that they put down and had gathered were not accurate of anybody that had their tribe on that page. And there's just because, like, Cheyenne River might have an aggravated assault crime, but BIA doesn't count that. I was trying to think of something better than that. Almost everybody counts aggravated assault. Or if it's simple assault, and nobody's actually differentiating whether it was a simple assault on his wife, you know, was it domestic violence or was it a bar fight? You know, none of that is even being out there. So BIA, which should be the point of contact and the point of expertise in this area, you've really dropped the ball. So to give you that, and DOJ, where they're getting their numbers, what she's talking about, they gather from the urban areas, and in the urban areas, it is without a doubt non-Indian perpetrators in the domestic violence and sexual assault and homicides. I'm sorry, data. And go on all day about
and
data.
with the in Lenape-Hocking in the data that we are analyzing, what data we can analyze, we're recognizing that there is a lot of misidentification, non-identification, and then misidentification, and there's a lot of racialization of Native peoples, and no account for intersectional identities whatsoever. And so that is also very problematic when you're trying to understand the scope of the problem, the nature of the problem in the urban spaces, because we presume that because urban spaces are different, the problem is looking different. But it's very difficult because either the police departments are not collecting disaggregated data at all, and if they are, they're looking at individuals and identifying them, and often then misidentifying them, and certainly most of those cases not identifying them as Native.
All right. Thank you for your question. And thank you, everybody, for just being here. And thank you all for sharing today. Yeah, thank you. Appreciate it. Thank you.
And thank you again to everyone who just shared all that amazing information. I mean, it's not amazing in that way exactly, but for folks in the room, I know that many of you have been with us since the top of the day. It's been a long day, so we will still have that 15-minute break or so. Let's try to come back at 5:35. That's 13 minutes, close enough, before we get started on our next part of the symposium. Thank you again, and water, drinks outside, and then dinner will be after our next panel. All right, thank you, everyone. I know many of you have been with us throughout the day. Others of you are just joining us. But thank you so much for being here today. I'm happy to introduce again, my name is Ashley Williams. I'm the chair of NYU's NOLSA. I'm happy to introduce Curtis Zuniga, the co-director of the Lenape Center. He will share the history of the forced removal of the Lenape, in addition to what brought him to his work, why it's important, where the Lenape Center is going next, and how others can support. Just by way of background, Curtis is co-director of the Lenape Center. He is an enrolled member of the Delaware Tribe of Indians, the modern-day descendants of the indigenous peoples of the Lenape-Hoking. He served his tribe in Indian country for nearly 40 years, including being elected chief 1994 to 1998 and cultural director 2017 to 2022. Curtis has over 30 years experience in government, leadership, community development, multimedia production, and cultural education. He's also a veteran of the U.S. Air Force from 72 to 78. Please join us in welcoming Curtis, and thank you again for coming.
All right, I'm mic'd, so I guess you all can hear me now, right? I'm gonna break the standard setup here. I think a lot better on my feet than standing behind a lectern. It creates a barrier. Yes, I am Curtis Zuniga. He kulmasi mahash no mohomo duluwensi alushi oquis sakima lanapeuk nulalinda muhana elipaek manahata Lenape-Hoking. I spoke to you in the Lenape language, introducing myself. My Lenape name is Alushi Oquis. It was given to me by a tribal elder many years ago. It means he is like a fox. Not foxy, but he is like a fox, you know, kind of crafty and gets around like that. And I welcome you. I am glad that you all are here in Lenape-Hoking, the land of the Lenape, the original homeland, on this island that we called Manahata, which really translated meant the place where they came to gather wood to make bows. That's the origin of Manahata. So I'm pleased to kind of close out the program today talking about Lenape Center. First of all, one of our projects that began and turned into a working group is on missing and started out missing and murdered Indigenous women, and then we added children, and it just kind of evolved into people, Indigenous people. And so Jocelyn, who was just on the panel with us, has spoken very eloquently about the work that's been done. And we're ever so grateful that she is affiliated with Lenape Center. I am a co-director. I've been involved with the organization for about 12 years now. And we started out like nobody knew anything about us. But let me try to quickly explain. Lenape Center is a small arts and culture organization. We exist to return to the homeland, this place we call Lenapehoking, and combat the erasure of our people from the history books, the public conscience. And some of that erasure included renaming places like Manhattan becoming Manhattan, but a lot of like the Hudson River, that's to us Mahiakanitut, the river that flows in both directions. But when Henry Hudson came down, you know, everything's Hudson now. Hudson River, Hudson Valley, all of that. These are examples of settler colonialism. Look, I've got a lot to say, and unfortunately, a short period of time to do that. So I'm going to try to run through this real quick. Lenapehoking, the original homeland, you could center it right here on the island of Manhattan. Go north up the Hudson River to about the foothills of the Catskills Mountains. When you start getting further north, you get into Iroquois country. That's a whole different kind of people. They're different Indians, different language, and sometimes we've had a bit of adversarial relations with them. But if you come down that entire Hudson River Valley, pick up New York City, and continue on in a very important geographic corridor between New York City and Philadelphia, and then going on past that. Now that means we're picking up all of New Jersey, eastern Pennsylvania, and emptying out into the Delaware Bay. That original homeland is an amazing piece of geography then and now. And yet, as I was introduced, I am an enrolled member and even a past elected chief of the Delaware Tribe of Indians. That's another part of settler colonialism. Our first encounter in the early 17th century was Henry Hudson coming down and looking for trade routes for the Dutch East India Trading Company. The fur trade was very robust, or becoming robust at the time. The Dutch established places like right here. I'm just going to throw some words out there. They parlayed with the indigenous people, the Lenape, looking for a place on the new land, the newly discovered by the Europeans. They looked for a place to establish a village. Then they built a fort occupied by military, again, ostensibly for trade purposes, but the Dutch were heavily influenced by the doctrine of discovery, which is like really in the news even today with the Vatican. I just saw this on a news feed. They're starting to disavow the Christian doctrine of discovery If you can imagine after Christopher Columbus discovered this continent, So word gets back to Europe about these endless possibilities, this endless land. And the term savages was used. Savages. And the Pope of the Catholic Church, starting with papal bulls, well, actually they preceded Columbus, but also after the Columbus discovery, like the papal bull of 1493, 1497. Other papal bulls are these edicts that were pronounced by the Pope, and they call it the papal bull because he used his papal stamp on wax to put that on these proclamations, and it was the symbol of the bull. Basically, the doctrine of discovery states that now that we have discovered these new lands with savages, and you got to understand, the Pope had his own army for several centuries. Basically, the translation out of Latin into, I'll speak English to you. You'll go to these lands, you will, that Latin word, dominos, was written a lot. Dominate. You dominate the savages. You convert them to Christianity. And once they are converted, you turn them into the working class. That means slaves. Those that resist, kill them. And don't worry, I'm the Pope. I give you full impunity. You'll go to heaven and be with Jesus. Just kill the savages and get them out of the way. Yeah, that's the kind of stuff that began this process of Europeans coming onto this land. Now, when the king, the queen, the pope, and everyone is telling you to go do this and take control and bring the riches back and then establish permanent settlements. The Dutch were really good at that. So they established New Amsterdam. And they built a fort around this land that they had purchased. I don't know, the more I talk to younger people, they don't even know about the so-called purchase of Manhattan. I got it in school. It took a long time for me to finally realize that that was a myth, even a lie, because the Lenape did not understand the concept of selling land. It was a gift from the Creator, and we had a responsibility to take care of it. Our lifestyle was one of living in balance and harmony with all of creation, and all of creation had a living spirit. The mountains and the waters likewise. They're our relatives. So the idea of selling land, they just didn't understand that. You get a title or some agreement, piece of paper, and suddenly they're disenfranchised from a piece of their own homeland. So you can imagine then this wall that's being built around this place that the Dutch believe they bought, the island of Manhattan. Here's a little trivia bit for you. So they build this wall. Then they had this path that traversed the perimeter of the wall. Pretty soon it grew to be wide enough, for horses and wagons. And then over a period of time, paved path along this wall that was built to keep the Lenape out of their own land that they thought that they were just sharing for shared occupancy. That's the egalitarian nature of the Lenape. They were called the grandfathers by other tribes for their ancient wisdom and oratory and an outright religion that they practiced. And yet, they were pushed out of their land with a wall that kept them out. And guess what, folks? That path that turned into a road, that turned into a modern paved street, here it comes. The street and the wall right here in New Amsterdam. That's where the name Wall Street came from, right? It was the center of trade and commerce for the Lenape right here on the river. And trade and commerce was not just in Lenapehoking. It was all up and down the eastern seaboard, even into in the Caribbean area. Wall Street, the street next to the wall that kept the Lenape out of their own homeland. Then come the British, more powerful military. They wanted to take control of the fur trade. By the way, there were a number of, it went quickly. It was no longer any kind of friendly relations with the Dutch. There were skirmishes, there were even massacres that occurred. One at Pavonia, New Jersey, what's now Pavonia, New Jersey. It's horrible to read about what happened back then. Look, it's not my story. This is stuff I read, the writings of merchants, military governors, missionaries, scientists, and other historians. It's their words that told about this. Then the British come. The British basically used their power and moved the Dutch out, and then they renamed New Amsterdam from a city in England, New York. The British colonial governor who came up from Virginia to take more control over the land that they took from the Dutch, Sir Thomas West, one of his titles of nobility, he was the 3rd Lord de la Warr. And de la Warr morphed into Delaware, and the native inhabitants and the river became called the Delaware River. So now you got the Hudson and the Delaware. It was named in honor of a British colonial governor, and the native inhabitants began to be called Delaware. So the British wrote about the Delaware, no longer calling them Lenape. We are still Delaware today. We're listed in the Federal Register. We are a federally recognized tribe. We're listed in the Federal Register as Delaware Tribe of Indians. So I say I'm a Delaware Indian, but I still refer to myself in our traditional name, Lenape, the original people. But there's an example again of erasure of a people. You rename land and geography and people based on the colonizer. Then there's this, you hear about tribes in the Southwest and a trail of tears where they were Southeast, forced out of the Southeast, ultimately into the state of Oklahoma. My tribe, Delaware Tribe of Indians, and our cousins out in western Oklahoma, we're now called the Delaware Nation, we had a forced removal of the Lenape people, forced removal of the Delaware. It started out in a small area like this, no longer being able to have Manhattan or Manhattan Island. But ultimately, we were pushed out of our homeland. Now, when I talk about that geographic region, let me turn around. Please don't be offended if I turn my back to you, but okay, so I'm gonna say north. And if you can imagine all of these different villages throughout Lenapehoking and that large of a geographic area compared to those times, was so large, and we had a series of these small villages, that we actually had two dialects in our language. The northern dialect, which we call Muncie, and the Muncie people were more in the northern section. I call them the Wolf Clan people. The French called them Loups. The Loups are the wolf, right? And but then when you get further south into South New Jersey and Pennsylvania and all, now we're talking about another dialect of the language, the Unami. So the Delawares in Oklahoma, we descend more from those that are affiliated with the area of the southern part of Lenapehoking. Now I differentiate that because over a period of time, starting with the Dutch, then the British, and then the Americans, I'm going to use words that are pretty strong. And again, normally this lecture, I could do in about 2 or 3 hours. I could probably teach a semester course in it. But what I'm going to say is we were forced out of our homeland with this concept of you come in and by right of conquest, you take control and ownership of the land, run the savages off, or you turn them into slaves. So we're talking about land theft and sanctioned murder, genocide. That's the kind of stuff we didn't get in school in our history books, but that's the reality. All right? So we get pushed out, but not just one homogeneous group of people with one great leader walking toward the west. Follow me, my people, we'll follow a new land. No, they were fleeing in a theater of warfare, violence, genocide, murder, racism, colonialism. And it occurred over about a 110-year period where different villages in different areas of Lenapehoking, some fled northward into Canada. My folks, we were pushed westward out of New York and New Jersey and Pennsylvania through Ohio. Murders and atrocities were going on then. Even the Christian Delawares, even the ones that have been converted under the Moravian Church and lived in these peaceful villages in Ohio along the Tuscarawas River, even they were killed and their villages were burned. There's an infamous massacre at Gnadenhutten in 1782. The American Army and a murderous band of a white militia. Didn't matter if they were converts or not. They went in and they took 90 men, women, and children, put them in the warehouse where they kept food. And to save money on their lead shot, where they didn't have to kill them, they used giant wooden mallets and smashed their heads like they were just pumpkins. That sounds horrible, but this is the truth. And we're remembering those days. We have annual remembrances at Gnadenhutten. We got Lenape that come in from Canada and Oklahoma and Wisconsin, because that's where our villages are today. Now they are recognized by the U.S. and the Canadian government. Again, I didn't write this up and make it up. We took this from the history books of the colonizer. Look, when I said that we have a connection with all of creation, this is the homeland. It's like our Earth Mother. It gave us life. And with the divine blessing of Geshe Mokong, the creator of all things, we had a lifestyle, life ways, teachings that kept us in balance and harmony. And when all of that was destroyed, we went into a survival mode. Again, a powerful outside force coming in, annexing land, burning villages, killing people so that they could take over the land. Now, if that bothers you a little bit, saying, "Oh well, this is great America, wave our flag," and we didn't do that. We're not that kind of people. Well, yes, it happened. And if you cannot understand the emotional toll that it had on us while this is going on with the French and Indian War, Revolutionary War, War of 1812. All of this going on, now the Europeans are fighting with each other on our land, and we're caught in the crossfire. What does that sound like, folks? Exactly what's going on in Ukraine today. So if you want to humanize that story, think about what the Ukrainian people, and we didn't have the power to fight back. Even when we tried to ally, when we saw the British fighting the French or the British fighting the Americans, we were struggling. Oh, we better ally with somebody just so that we can stay alive. Ultimately, yes, we were pushed out. Ultimately, my band, the Delaware Tribe of Indians, ended up going through Ohio, Indiana, into the state of Missouri when it first became a state in 1821, later into Kansas, had a large reservation in the corridor between Lawrence and Leavenworth, Kansas. And then after the Civil War, the railroad companies coveted all of those lands in Kansas. They wanted to build new railroads to go to the west. They wanted those Indians out of the way. So the Indian wars are still going on out in the plains, but the crafty Congress is passing these laws. And they have, I don't know if this was discussed earlier, plenary power. So I don't know, did that term come up today? Yeah, right. It's amazing how the vestiges of that are still around. So they just forced yet another treaty. Here, sign this treaty. Okay. And we had to give up our reservation in Kansas and the promise that no more movement. Your last movement will go to the Indian Territory south of Kansas. And they even craftily found a little plot of land that the Delawares could move to. It was within the Cherokee Nation. Cherokees had been there since the 1830s. On July 4th, 1866, the United States of America entered into a treaty with the Delaware Nation. On that same day, they entered into a treaty with the Cherokee Nation. Cherokee Nation, you will settle friendly Indian tribes coming down from Kansas. That would be the Delaware, the Shawnee, the Wyandot, the Miami, the Ottawa. There's some examples right there. Delawares, you will sell your reservation in Kansas, use that money, and you'll pay the Cherokees for the right of occupancy in the Cherokee Nation. Why would the Cherokees accept all of these Indians into their nation and being forced to do so? That's because the Cherokees were slaveholders. There were well-known Cherokee slaveholders, and they fought for the South. The last surrendering Confederate general in the Civil War was Stan Wadey and the Cherokee Brigade. So the Confederacy loses the Civil War. To the victor goes the spoils. And so they were punishing the Cherokee by making them take in all of these other tribes that they got out of Kansas so that they could take over those lands. And they forced the Cherokees to accept, among others, the Delawares. Now, from the agreement between the Delawares and the Cherokees in 1867 until now, we have lived within the Cherokee Nation. And it's not always been a friendly relations. It kind of is now. But I mean, we even had to go to the Supreme Court twice in the early 20th century over disputes of occupancy and rights as, we paid to have rights as citizens of the Cherokee Nation. We paid for it, it's documented. I'm a citizen of the Cherokee Nation. Go over here to the parking garage, you can look at my car, I got a Cherokee car tag issued by Cherokee Nation. As a citizen, I don't have a lick of Cherokee blood in me. It's all a legal and political designation, all right? But isn't that something? Cherokee Nation can issue car tags, but we can't. That's all machinations of Bureau of Indian Affairs and Department of Interior. Regardless, and I know we're running out of time, I have to give you that background to talk about why are the Lenape here in New York and in Philadelphia and in New Jersey? Our tiny little arts and culture organization, we're not a tribe. We don't bestow recognition and issue card tags, and we're not a government. What we're trying to do is share this lesson, this history lesson, and realize that we should return to the homeland and take our rightful place at the table of power, whatever table that might be. Economic power, religious power, political power, education, culture, the arts, music, everything that's out there. The Lenape can and should return to their homeland and take their place at the table of power when we are finally recognized and we get a chance to speak for ourselves. For a while, others were speaking for us until they completely removed us. Then they didn't have to speak about us at all because we didn't exist anymore. Lenape Center is established to, our mission is to call for the return of the Lenape to the homeland. Just last year, I moved from Oklahoma here to the state of New York. And the way I am manifesting that call to return to the homeland, besides doing these kinds of lectures, and I do that a lot. I'm doing a lot of writing, history essays and the like. But for me, it's that idea of being connected to the homeland, our Earth Mother. When I return to the homeland and I stand on the banks of the rivers, man, I take my tobacco out and I offer tobacco and a prayer of thanks. Thank you, Wanishi. Thank you for allowing me to return to the homeland. Because for me, I am a generation down the road from a people, and again, I'm using that Ukraine war as an example. You have generations of Lenape that are constantly uprooted in a theater of war and violence and racism and hatred and near genocide. And that I can, in my generation, after so many, we've had this, what's now known as generational and historic trauma. Right? And you carry that with you. Our children are born in that world, and they carry that trauma with them, and then you wonder why we have all of these social problems and this identity problem. And we have to oftentimes either go along with it. If we try to fight it, We don't have the power to do that. So this trauma becomes collective in the generations. You can add the Indian boarding schools, which is yet another subject, but I'm watching the clock. For me, the way to overcome my personal trauma that has been carried from generation to generation to generation, and I didn't realize why my father was so tough, I mean, physically violent. I thought, what did I do to deserve this? Why are you being like, I was scared of my father. Well, he got his parenting schools in the Indian boarding school. He went to Shalako Indian School, where you're converted to become little brown-skinned Christian white people. Your culture is gone, your language is gone, Indian clothes are burned, cut your hair. You're gonna be like we want you to be. That experiment went through the 1970s, folks. I'm just an example of carrying this generational and historical trauma. And for me, the way that I have since last summer, the way that I have tried to return to the homeland, take my place in our homeland. I've become a gardener and a farmer. I have researched and acquired ancestral seeds of crops. Last summer, I started growing a field of sesapsing. It's a Lenape blue flint corn. We found writings of Dutch merchants in the mid-17th century writing about the Lenape growing corn in this valley. I'm living now up by Kingston. They were writing about growing that corn in this valley, right? And here I am, hundreds of years later, we found seeds. Some of them we found in a seed bank at the University of Iowa, right? Now I'm taking this corn and I'm planting it in the very same place that the Dutch wrote about the Lenape were growing corn back then. I've got corn, beans, squash, tobacco, sunflower, sunchokes. This summer I'm going to start gourds. That's how I'm returning to the homeland. That's how I am healing the generational and historical trauma that I carry with me, and I'm an example of hundreds and hundreds and hundreds of Lenape people, and by extension, indigenous people that were forced out of their homeland. And I humble myself when I walk into that field, when I walk into my garden. And if you all are gardeners, the way I really humble myself, I have to get on my knees and start pulling weeds first. But when I dig my fingers into the soil to plant seeds, I am organically connecting with my Earth Mother. When I am drawing water from the rivers to irrigate my plants, my relatives, I put my love and my sincere, deepest effort into raising these crops so that they will grow healthy and well. And then when I consume that food, it brings health and wellness to me and helps me overcome generational and historical trauma. That's but one example of the return to the homeland. And Lenape Center has taken that message and we converted it into, just last year over at the Brooklyn Public Library, a major exhibit called Lenape Hokie. And we had art, history. I wrote an essay about what I'm talking about now called The forced removal of the Lenape. But we have these really, a lot of art, beadwork, the Lenape men's bandolier bags. We have several on display. We even took a tapestry of the Lenape purple kinsessing and blue Shakamaxon beans that we collected where they had trellised up and we turned it into a tapestry, put it on display at the library. People love that kind of stuff. But that's, like I said, that's the organic manifestation of our return to the homeland. It is providing healing and wellness. Before I can advocate that, I have to demonstrate that. It's not words, but deeds too. Lenape Center is growing. All throughout the homeland. We dig this. One of our Lenape Center co-directors, Brent Michael Davids from the Stockbridge-Muncie Reservation in Wisconsin. He is a well-known Native composer, orchestral works, opera. He wrote a performance opera called Purchase of Manhattan. We were performing that at the Collegiate Church in Midtown in the sanctuary. And just 3 nights ago, Brett wrote a new orchestral piece. Dig this. You were there. I got to stand on the stage at Carnegie Hall and introduce Brett and this new work, and he came out and told people about it. So we got this orchestra performing work by a Native composer about Lenapehoking. So we're covering, like one day I'm on my knees pulling weeds in a field, and the next day I'm standing on the stage at Carnegie Hall. I mean, I kind of thought that was pretty cool. There's a lot more I can share with you. And if you see Lenape Center popping up at different libraries and museums and educational institutions, and you've got a chance to come visit us, we're doing something at The Shed, which is a big art performance space on Saturday, April the 8th. And we're going to be reading from the Lenapehoking anthology. I guess I should go ahead and like that. I thought I had more time, but I'm just grateful. I truly mean this. I'm grateful that we were included here, and I hope to come back and share more stories. I encourage you to do your own research and think about our story as a microcosm of all of Indian country and what they've gone through. And perhaps it might influence your work in law, whatever that work may be. And with that, I'll just go ahead and stop right there and offer my profuse thanks to New York University School of Law and the Native American Law Program, student organization, and to all of you, Wanishi, which means thank you. Lapich Kanewa, I will see you again.
Thank you, everyone, and thank you so much for sharing those words. On behalf of NYU's Native American Law Student Association, again, thank you to all of the panelists and speakers throughout the day. In terms of next steps in the program, there's food outside that you can grab, some burritos from Chipotle. Feel free to stay around and chat. We have the room for quite a bit longer. But before we conclude the event, for those who missed my introduction at the beginning, my name is Ashley Williams. I am the chair of NYU's Native American Law Student Association. I am originally from Tulsa, Oklahoma, a citizen of Cherokee Nation and descendant of freedmen. I spent a lot of time in Texas before law school, and I'm very happy to have revived NYU's NALSA. And it is definitely something that is not going to go away. We're doing all we can. We're a small but mighty group.
And we plan to continue having these types of conversations and making sure that NYU law and the field of law is one that can put Indigenous voices at the center. In addition to NALSA, we want to thank the Center on Race and Equality and the Law for their amazing partnership in this work, Law Women, the Law Alumni of Color Association, the Women of Color Collective, Outlaw, the Education Law and Policy Society, Public Interest Law Student Association, Review of Law and Social Change, American Constitution Society, the Black Allied Law Students Association, and the Latinx Law Students Association. All of those organizations supported us so that we could be here today. Thank you. Okay, and Marguerite has an announcement.
Labor Day weekend. Or it is not then come before. We have beautiful territory, we've been there many times, and beautiful territory. We're hoping to get the museum open soon. But certainly, again, what nurtures us is good drumming, good dance. That's what we'll see it. From the east end of Long Island, some of you may be golfers with lots of money, in which case you'll go there. That perfect, some of you fishermen, find some good fishing out there, but we have a good time. We have a good park. This doesn't give place to sit on the beach and think creators giving us.
And that includes great wampum work.
And great wampum.
Thank you for the gracious invite. And again, thank you all for coming today. And that will conclude our official event, and feel free to go outside and have some food. Thank you.
Well, we can talk again down the road.
And then we'll follow up with logistics on the sort of honorarium. I know that sorry to talk shop, but I just want to let you know, I know Professor Gutkin is going to donate her honorarium to the Lenape Center. It might be easiest for us to send it directly to you, if that's okay, or would you not? We can.
I'll have to talk with your administrative office too. Typically, what we like to do is we simply ask for a donation to Lenape Center, but it's through our fiscal partner that handles the nonprofit part. They're the New York Foundation. I can give you all that information, including their W-9, and we can produce if the money goes directly to the Lenape Center, it becomes problematic. Then I'll take it, just do it. But we got time to follow. I'm like my early days. I don't need the money now, so I can catch the train back home.
All right, good to know. But we'll definitely follow up with that and get all that squared away. But thank you so much for coming in.
Sure.
That was amazing.
We can take a picture of them.
Yes.
Actually, I think I would send you.
Yes, thank you. I saw you taking pictures and videos and I was.
And also, I hope this man will be there and speak now. And I would like to introduce you. So let's take a picture.
Let's do
He wants to go.
Sorry to take you in your comment. Sorry. I'm sorry.
Have received an email. If you can send me a WhatsApp, because
No, I.
But for me, it was, in order to, you know, hear talking what occurs in a map, because of the story, even read some of the story on the book, it was another energy because it was so I took the video and I thought it was too much, but I will send it to you. Yeah, that was a big I knew because I knew that it was a thing all the day. But it was very interesting and I felt very thinking but not like because of here. I felt really connected and very close to my way of thinking. So thinking the future I might want to see that's interesting. But anyway, no, I will bring back my publisher, asking him his investment for education. So if the number is that I can help by also bringing the story. I have my copy. Yes, if for the publisher, yes, that would be amazing. And well, I will chat with Joe on Saturday. I will spend my day with Joe. So thank you so much. So he will explain to me what you have on plan and whatever you tell me. And if you have this environmental background also to share with me, I can write that in French. I can publish that, whatever I can do, just let me know how I can be the more useful